Move on. The last bill you have is Senate Bill 617.
Thank you, Madam Chair. The last bill, as the Chair just mentioned, is 617. It's titled the Reform Solitary Confinement Act, or how it is actually known in the DOC circle, Restrictive Housing. I want to just very quickly thank the advocates who have worked tirelessly for years on producing this document that you have in front of you. Some of the very high-level things that this codifies, which are in some instances already practiced within the Department of Corrections, is an evaluation within 72 hours of being put in restrictive housing and every 14 days thereafter, reasonable access to programming, which includes food, legal and medical assistance, and others, a review after 24 hours of being placed in restrictive housing and every 7 days thereafter, a minimum of 2 hours out of cell in certain conditions, and a minimum of 4 days out of cell in other conditions. So administrative confinement versus a punitive confinement. It adds a provision that says that no person under 22 or over 60 or a vulnerable population shall be held in restrictive confinement. The 22 limit is based on developmental stages of a person, and so how long it takes for someone to be thinking like an adult, moving like an adult. 60 aligns with the redefinition that we gave to senior populations in Rhode Island last year, actually. So we consider now a senior population a protected class of those that are 60 and up. And so this was written to align with that. I want to shout out Bob Marshall from the RI Developmental Disabilities Council, who submitted a letter in support, particularly around this part about members of vulnerable populations. And it also establishes an oversight committee. So as I mentioned before, some of these pieces are already in place as practice, not necessarily codified in law. But one of the things that this would be adding is an oversight committee that would be providing oversight for how solitary, or rather restrictive housing, is carried out in our state. I do know that there's pending litigation that the department is working through and figuring out how to implement some of the recommendations that are coming out of that. So I look forward to continue working with them, to continue working with advocates, and Rep. Felix in the House side, who's been working on this as well. But I'm happy to answer any questions that you may have.
Thank you, Senator. Are there any questions of the sponsor on this legislation? All right, I do not see any. Thank you so much.
Thank you all.
Next up, we're going to move to Senate Bill 617. I'm going to do my best to take folks up in order that they signed up, but I have multiple pages that are of testimony on this piece of legislation, and there's a lot of them that are listed as page 1. So I'm going to do my best to get folks up in order that they testified, and I will tell you that I will fail because there's not a clear order to how folks signed up. So I'm going to call up Wayne Salisbury, Joshua McComber, and Natalia Friedlander. Welcome to the committee. We'll start at my right.
Good evening. Can you hear me?
Yes.
Hi, Madam Chairwoman, thank you so much for the opportunity to testify, and thank you to members of the committee. My name is Natalia Friedlander. I'm an attorney at the Rhode Island Center for Justice, and among other things, I do litigation and advocacy on behalf of people who are incarcerated on conditions of confinement. So in that capacity, I've talked with many, many people who were incarcerated in solitary confinement or restrictive housing, as the Department of Corrections calls it. And I'm currently representing 2 individuals who were sentenced to 365 days in disciplinary confinement, each of whom was for a single nonviolent offense. And disciplinary confinement is characterized by serious limitations in out-of-cell time. At the time that they were sentenced, it was characterized by 1 hour out of your cell each day, Monday through Friday, except holidays, and serious limitations on contact with family and loved ones. And so what this bill would do is to codify some basic minimum entitlements for people who are incarcerated at the ACI who might present a risk to security. And I want to first say what it wouldn't do. It wouldn't limit the ability of the DOC to penalize people who break prison rules. It wouldn't limit their ability to take people out of general population who present a risk to safety and security. But but it would guarantee that after 15 days of confinement where someone's let out only 2 hours a day, they would be given a minimum of 4 hours out of their cell every single day, which is the very basic minimum that research has shown over and over is necessary to be kind of a functioning member of society who has a chance at rehabilitation and at getting back out into general population. And the most significant thing about this bill, I think, is not necessarily what it says, but the fact that it says anything at all. And that's because Rhode Island is a serious outlier in terms of how much the general laws regulate the functioning of the Department of Corrections versus how much discretion is given to the director of the Department of Corrections, and that virtually all day-to-day activities of prisoners, virtually everything about day-to-day inmate life is delegated to the director of the Department of Corrections, who's then authorized to promulgate rules, regulations, and policies concerning prisoner life. States all up and down, or not states, but courts all up and down have found that these internal DOC policies, they're unenforceable and they're non-binding as to the DOC actions. And so what this means is basically that there's very little oversight and accountability over the actions of the Department of Corrections. It's not regulated by statute, and prisoners have virtually no recourse when those policies aren't followed. And to the extent that changes around restrictive housing practices, solitary confinement, may happen voluntarily, that's extremely commendable. But our concern is that even if changes happen in one administration, another administration could come in and could revert those changes. It can institute policies and regulations that are even more harsh and draconian than what we've seen in the past. And we're also very well aware we can't comment on litigation, but there are serious limitations under the Federal Prison Litigation Reform Act on how much can be changed by courts long term. And so what this legislation does, what this bill would do, is it would codify some of these basic protections, some of these basic minimum entitlements, so that we're not reliant on the goodwill of any particular agency or administration, and it places very necessary guardrails in place so that even as agencies change and administrations change, that prisoners are given these very basic minimum entitlements. And you'll hear about some of the reasons why this legislation is necessary from some of the other people who are testifying. Thank you.
Thank you. Are there any questions for this witness? All right, seeing none, welcome to the committee. If you want to go ahead and introduce yourself, you can go ahead with your testimony.
Good evening, Madam Chair and members of the committee. I appreciate the opportunity to sit before this esteemed committee this evening to speak on this legislation. For those of you I have not had the opportunity to meet, my name is Wayne Salisbury, and I am the Acting Director of the Department of Corrections. I am humbled and honored to serve in this role and understand the enormous responsibility I have to the offenders entrusted to the department's care, the staff, its vendors, community partners, and to the family, friends, and constituents of our great state. Before I speak to the legislation, I believe it is important for you to know my background. I sit before you this evening with 36 years of law enforcement and corrections experience. I served 6 years on active duty in the United States Air Force as a law enforcement specialist and trainer performing police and corrections duties in the United States and overseas. Following active duty, I began my career as a correctional officer and promoted through the ranks of sergeant, lieutenant, captain, chief of security, associate warden, and eventually warden. During those years, I was an instructor certified in various use of force modalities, such as firearms, defensive tactics, chemical agents, and baton, to name a few. More importantly, I was a trained crisis negotiator, a skill most utilized and necessary in dealing with offenders. Lastly, I was a certified auditor for the American Correctional Association for over 13 years, having the ability to travel around the country and observe and evaluate other correctional systems and agencies. In March of 2016, actually 7 years today, I joined the Rhode Island Department of Corrections as a deputy warden and was assigned to the Intake Service Center, and within a year assumed the acting warden role. In October of 2020, I was promoted to the role of Assistant Director of Administration and into my current role in January of 2023. Shortly after joining the department in 2016, I joined the National Institute of Corrections training staff as an instructor in managing restrictive housing populations, becoming the lead facilitator in 2020. I have facilitated restrictive housing training for nearly 80 agencies around the country and have consulted and assisted many agencies on this very subject, most recently assessing the Pontiac Correctional Center in Illinois in October of 2022. You will certainly hear testimony tonight contrary to what myself and my staff will say, most of which may have occurred 10 years ago or more. The emotions associated with this topic will make it difficult to ascertain what is true or false. Sadly, some of it is true. What I can tell you unequivocally is that the stories you will hear tonight do not represent the current practices at the Rhode Island Department of Corrections. I will say that if that's their perception, and I'm speaking to the formerly incarcerated members of the group behind me, then it's their reality. I respect their reality, and I will use their reality in our reformatory efforts. Let me speak briefly to solitary confinement and move on to the legislation. Restrictive housing has long been a feature of America's jails and prisons. The justifications for its use have varied over time, and so has the acceptance of its practice. Solitary confinement is complete sensory isolation and total social isolation. Complete sensory isolation coupled with total social isolation can destroy the personality and constitutes a form of inhumane treatment which cannot be justified by the requirements of security or any other reason. Solitary confinement has been widely abused across the globe over the years out of fear who we were dealing with or being mad at the offender. Why is this important to the members of this committee? It's important to understand where we came from, where we are, and where we're going, to include some lessons learned along the way. This is not who the Rhode Island Department of Corrections is, nor will it be. The department is committed to being transparent, and in doing so has invited countless members of the legislative body to tour our institutions. Our restrictive housing population is about 5% of our total population, which is less than half of where we were just a few years ago. As you are aware, the department is currently in federal litigation and mediation regarding restrictive housing and have 2 neutral court-appointed monitors that have worked with all the parties for almost a year. We have made a significant progress in our mediation process, and I firmly believe that if we are able to further navigate this process, this legislative body and our reform advocates would be pleased with the outcome. It is important to keep in mind that a crucial part of our mission is to contribute to public safety by maintaining a balanced correctional system of institutional and community programs. We do not have solitary confinement. More than just a change in terminology, our restrictive housing practices are well-crafted step-down programs that seek compliance through the use of privileges rather than retaliatory methodology. In other words, the more the offenders comply with the rules, the more privileges they are awarded. We are providing a range of custodial options, supervision and rehabilitative services to facilitate successful offender reentry into general population and to the community upon release. We have increased out-of-cell time and allowing the use of TVs, radios, tablets, and MP3 players inside of cells. To that end, we implemented a series of step-down programs to manage offender behavior and to ensure safety inside of our secure facilities. Captain Joshua Maycomber, to my right, will speak more specifically to these changes in his testimony. We've established a residential treatment unit for qualified severely persistently mentally ill, SPMI, offenders, along with a behavior modification unit. Acting Clinical Director Caitlin Bouchard will speak directly to these matters and the clinical treatment of those in our care in her testimony. Although there is a national trend to impose legislation on restrictive housing, it can lead to disastrous results. The Department of Justice publishes guiding principles concerning the use of restrictive housing in January of 2016. And nowhere within those principles does it call for the elimination of restrictive housing, limitation of disciplinary confinement to 15 days, restrictions on age of anyone under 22 years of age or someone over a certain age, or other items within this legislation. Much legislation has been modeled after Rikers Island in New York State around the country. Members of this committee, as many jurisdictions are seeing around the country, one size does not fit all, as each correctional system is different in so many ways. Within New York State, according to reports for September of 22, since the implementation of the HALT Act in April of 22, there were over 1,000 assault incidents, with the overall prison violence going up 27%, of which 88% of the assault incidents resulted in staff injury. I say this not to deter us from reform, but to caution us to the pitfalls. We deal with real people with real issues and people that have proven to be violent, assaultive, and a threat to the safety of others within our correctional system. The staff within the department are dedicated to providing safe, secure, and humane facilities throughout our complex and do a tremendous job with the resources and space we have available. We are not perfect, nor do we claim to be, as we are all human just like those we manage. We strive each day to make today better than yesterday for offenders and staff alike. We are a work in progress, and we're constantly evolving just like the history of restrictive housing, just at a faster pace. I began my testimony this evening speaking of the incredible responsibility I have to ensure the safety of all entrusted to the department's care, to include its offenders, staff, vendors, visitors, and all that pass through the walls of our facilities. With that comes great authority. I ask that this body not jeopardize the safety of our facilities by imposing such broad legislation that imposes upon the director's authority while still making them the responsible party. I'll be pleased to answer any questions you may have.
Thank you. Are there any questions for this witness? All right, I do not see any. Captain, go ahead.
Thank you, Madam Chair and members of the committee. My name is Joshua Maycumber. I have served in the state at the Department of Corrections for 24 years. The last 14 years as in a supervisory role as lieutenant. This year in February, I had the honor of being promoted to captain. I have spent most of my career at either high security and maximum security, two of our most challenging facilities to manage. As the legislators who have toured high security have seen, our officers and supervisors strive to provide the safest and most secure environment possible. This requires awareness and sound judgment during each minute of each shift. The individuals my team and I look after and care for present a variety of complex challenges and needs. A phrase we use in corrections is care, custody, and control. It is in these considerations that allow for opportunities for rehabilitation or dictate how an individual must otherwise be managed. It is our role to foster and help maintain a clean, safe, and healthy environment that lends itself to these goals and priorities. Officers spend more time with the incarcerated population than anyone else, to include their own family members at times. As sworn peace officers, we have a duty to protect them from one another and unfortunately many times from themselves. As important as it is to end an incident that is occurring in real time, it is equally important for us to prevent incidents before they happen. Officers are usually the first to detect an issue or red flags with someone. We notice if they miss a meal, miss a visit, refuse recreation. We sense if they are depressed, upset, or scared. We observe their interactions with their peers. All of this done by proactively engaging with the population and treating them with respect and as people. Ultimately, they depend on us to ensure their safety. When we notice someone is off, officers engage with and triage their issue or issues. Depending on what these issues may be, mental health is notified, medical staff is notified, supervisors are notified. Our policies and procedures today, including restrictive housing, are not capricious and arbitrary. There is a logical reason for each policy and procedure we follow. If an individual in our custody is not permitted to have a particular item in their cells, it is based upon a previous event or circumstance which created a risk or danger to that individual or those around them. I could provide countless examples of real-life incidents that have resulted in changes to our policy or procedure designed to enhance the safety of individuals. I'm proud of the work I have done over the course of my career, particularly the contributions I have been able to make to the RIDOC as it works to continuously evolve its operations in a manner that is consistent with the best correctional practices. The sad reality is that many of our facilities do not lend themselves to best correctional practices, as they were built in a time when program and rehabilitation were not prioritized as they are today. In my opinion, as a correctional professional, a reduction of sanctions as proposed in this legislation makes an already challenging and difficult job of keeping those who depend on us to keep them safe even more challenging, if not impossible. I'd like to thank you for the opportunity to speak, and if you have any questions, I'll do my best to answer them.
Thank you. Are there any questions for this witness? All right, I don't see any. Thank you all for your testimony. Next up, we have Caitlin Bouchard. Bella Robinson signed up in support. Stephanie Soto signed up in support. We also have Brandon Robinson and Alicia Liberty. And welcome to the committee. Caitlin, if you want to go ahead, introduce yourself. Just make sure the button is up.
Can you hear me?
Yeah. Try that again.
Hear me now?
It gets stuck sometimes. There you
Now. Okay.
go. Go ahead.
Thank you, Madam Chair and members of the committee. I appreciate the opportunity to return to testify here this evening. My name is Caitlin Bouchard, and I'm the Acting Clinical Director for the Rhode Island Department of Corrections. I have spent more than 15 years in correctional mental health care, serving as a clinical programming services provider, a clinical social worker at the department's Intake Service Center, maximum security and high security. I've been in a supervisory role since 2014, and in my current role since April 2019. I currently oversee our behavioral health team, which consists of 13 qualified mental health professionals. This includes master's level clinicians, licensed independent clinical social workers, and licensed mental health counselors. RIDOC has contracted psychiatric services, Rhode Island Hospital, Department of Psychiatry, as well as a forensic fellowship program with Eleanor Slater Hospital, with psychiatric services provided to the correctional population by forensic psychiatry fellows. Our mental health professionals provide services 7 days a week with first and second shift hours and on-call services 24/7. Psychiatric clinics are held 6 days per week with 24/7 on-call psychiatric coverage for emergencies, which unfortunately are not uncommon. The Department of Corrections has taken a proactive approach to addressing the needs of the severely and persistently mentally ill, or SPMI, patients. In February 2018, we opened our residential treatment unit, which is a treatment-intensive programming unit housing SPMI patients who are identified as requiring a higher level of care as a result of functional impairment that impacts their ability to be in general population. The unit focuses on moving these SPMI patients out of restrictive housing and into a therapeutic treatment setting. Each patient has an individualized treatment plan that includes psychotherapy, evidence-based treatment programming, psychiatric occupational therapy, medication management, and their progress is reviewed monthly by a multidisciplinary treatment team. A second specialized treatment unit is currently in the final stages of development that would provide a long-term housing placement for SPMI patients who present with more complex clinical needs, including those with personality disorders, impulse control issues, and those that generally have difficulty functioning in general population. This unit will divert SPMI patients from restrictive housing and provide them with enhanced clinical programming and additional supports. We expect this unit to be operational by fall 2023. The clinical treatment team reviews all disciplinary infractions daily. The electronic medical record of any patient with an infraction is fully reviewed to determine if there are any active symptoms or functional impairment that contributed to the infraction. Any SPMI patient who receives a disciplinary infraction is assessed within 24 hours by a qualified mental health professional in a confidential out-of-cell session. For patients not designated SPMI, if mental status is suspected to have played a role in the behavior involved in the infraction, they will also be assessed in the same out-of-cell confidential evaluation. If mental status is found to be a factor for any patient in the Department of Corrections, this is reported by policy to Shift Command and is a key factor in the disciplinary hearing process. All inmates or patients placed in restrictive housing are consistently evaluated by the clinical treatment team to assess their mental status and provide them with clinically appropriate mental health and psychiatric treatment for the entirety of their placement. If a patient is receiving active treatment services, then their treatment plan continues without interruption when they go into restrictive housing. Their treatment plans in restrictive housing include focuses such as identifying whatever maladaptive behavior may have contributed to their placement in restrictive housing, development of adaptive coping skills, increasing frustration tolerance, and we also use all evidence-based practices, cognitive behavioral therapy, dialectical behavioral therapy, trauma-informed care, and our main focus is preparing the patient for reentry either into general population or back into the community. All patients in restrictive housing have access to confidential out-of-cell sessions with qualified mental health professionals. These professionals are present in the unit for weekly rounds with often daily presence in the units depending on the facility. They're consistently assessing patients for any emergence of clinically significant symptoms, distress, or functional impairment. Additionally, they check medication compliance and monitor activities of daily living. Mental health professionals consult daily with correctional and medical staff regarding their observation of the patient in restrictive housing as it relates to changes in behavior, presentation, sleeping and eating patterns, and medication compliance. This collateral information, combined with ongoing clinical assessments, ensures that those in restrictive housing are consistently assessed for any signs of psychological distress. Patients in restrictive housing can request to meet with a mental health professional at any time, and the department prioritizes the accommodation of such requests. I am proud to be part of the department's continued organic evolution in how those in our custody receive care. And as we continue through our ongoing mediation and litigation, I am confident that further progress will be achieved to the benefit of our patients in the department as a whole. Thank you.
Thank you. Are there any questions for this witness? All right, I do not see any. Welcome back to the committee. If you want to go ahead and introduce yourself, you can go ahead with your testimony.
Thank you for having me. My name is Brandon Robinson. I'm the community organizer and lobbyist for the Reform Solitary Confinement Act. I have a bachelor's degree in organizational development and leadership, and I'm working on my master's in public administrations. At 19 years old, I was sentenced to 50 years with 28 years to serve. On that 28-year sentence, I served 16 years total. In the first years of that 16 years, I did 4 years in intake service center, and after that, I did 8 months inside high security. From there, I did 10 years in medium security. During the 4 years in intake service center, I did 90 days in solitary confinement and the 8 months in high security afterwards. The conditions inside those two places were horrible. I seen childhood friends who were in high security for 5 years, and individuals who were there less losing their minds. They were deteriorating. So much so that they now cannot cope in the outside world. They're not able to maintain personal and professional relationships, which and the end result of that is they continuously go in and out of prison, despite being locked up so long. During my time incarcerated, I've seen many people take their lives just because they couldn't cope with the time there, from slicing their wrists, and when that didn't happen fast enough, they hung themselves from their bunks. As a porter, it was my job to clean up those cells and clean that blood with bleach and untie those knots. Those conditions were so bad, if you look at my institutional record, you'll see that from the whole 10 years, I got in no trouble. My experience in high security was such a deterrence from wanting to go back to a place like that, because that was my first experience as an adult, being inside the ACI. And that's what I experienced. I experienced 4 years in intake, which is the cumulative of being in solitary confinement, because you're locked in your cell so much and so often, and then high security. So if you look at my institutional record, you'll see that I had no other disciplinary infractions, and instead what I did was I used my time to help others by teaching classes for 7 years and trying to help other people avoid going back into the system, try to help them get rehabilitated. What our bill does is it's looking to reform solitary confinement. We understand, if individuals make mistakes, they need to be held accountable, but they're already being punished by being incarcerated. And just because they're incarcerated doesn't mean they don't have rights. And so what the bill does is affords them that opportunity to have a chance of getting rehabilitated, because they're already being punished. When you have a child or you're a pet and they do something wrong, you discipline them, right? But when you discipline them, you're not looking to torture them, you're looking to discipline them, right? Everybody needs to be held accountable. But what's happening currently in the ACI is we're being tortured. People are being put inside solitary confinement for extensive amounts of time, years on end, to the point that they start to hallucinate, they start to talk to themselves, they start to become suicidal. At the time when I was seeing it, I didn't know what it was called. I now know it's called sensory deprivation. Sensory deprivation is a clinical term for what individuals start to experience while in these conditions. It's a perfect example of this is Tom Hanks and Castaway, when he was stuck out in the ocean and all he had was the volleyball and he called it Wilson. And he talked to that volleyball in order to survive. That's exactly what individuals have to do in high security and solitary confinement to survive those conditions. Despite all of that, for myself, I happened to be able to make it out because I had a chance to get rehabilitated. My time in high security was so scary, like I didn't want no parts of it. Other individuals, they wasn't that fortunate. Some people didn't make it out, and some people continuously recidivate. But one thing that this bill does with the reformation of solitary confinement and those 4 hours out of cell gives individuals an opportunity to participate in rehabilitative courses and educational programming. And statistics say the more education an individual has and the more rehabilitative courses they participate in, the less likely they are to reoffend. So these individuals that are having this opportunity with this bill being passed, they're going to return to our community and have a chance to develop personal and professional relationships. Now, I got to ask you, is that what you want for individuals that paid the time for their crime, came back to our communities, be able to have a job and participate, or would you like them to make somebody else a victim? Because that's what's happening right now, the way the ACI is handling solitary confinement and high security. Thank you for giving me a chance to speak.
Thank you. Are there any questions for this witness? All right, I do not see any. Welcome to the committee. If you want to introduce yourself, you can go ahead.
Thank you. Good evening. My name is Alicia Liberty, and I would like to start by thanking you for allowing me here to speak on behalf of my sister, Charlene Liberty. I'm here today to discuss the definition of torture and how the ball of humanity has been dropped by the Rhode Island Department of Corrections. By definition, torture is the action or practice of inflicting severe pain or suffering on someone as a punishment in order to force them to do or say something. The Nelson Mandela rules was created so all prisoners shall be treated with respect, dignity, and be valued as human beings. Today, I compare these rules to the inhumane treatment of my sister, as the severity of her mental illness was being ignored. She had serious and persistent mental illness. Mandela Rule 43, in no circumstances may restrictions or disciplinary sanctions amount to torture, inhumane or degrading treatment or punishment. A statement by Charlene to the ACLU. I was aggressively thrown into segregation, left alone with my thoughts and emotions, making things all that much worse. There is nothing positive. Only feeling less than human, depressed, unworthy, seeing things on the walls, and talking to yourself and wanting to kill yourself. Charlene would attempt suicide because of isolation. Then she would go to the hospital for treatment to only return to isolation as a punishment for wanting to die. And the vicious cycle begins again. So I ask, who is going to care enough to break this cycle? Charlene was shackled so she couldn't move. She wasn't a threat to anyone, not even herself. Yet if she cried and said she would rather die, she got maced in the face to shut her up. Charlene attempted suicide by hanging herself and self-mutilation, running her head against walls, diving off sinks and toilets to break her own neck. I'm going to tell you, that's not who she was before she went in there. Medical staff noted in her record that he was so overcome by pepper spray that he had to immediately put a mask on in order to re-enter her cell. And when he did, she was foaming at the mouth, bluish discoloration around her neck and her face. And she was twitching like she was having a seizure. So why would they mace her? Because it seems to me she was unconscious from hanging herself. When she returned from intensive care, she was immediately placed back into solitary confinement. She clearly needed a psychiatrist, not more isolation. Mandela Rule 45. Solitary confinement should be prohibited in the case of mental disabilities when their condition would be exacerbated. Charlene's serious and persistent mental illness was very apparent and could not be denied. She turned in multiple grievances, and she was completely ignored, leaving her to feel that her only way out of this was to die. So I sit here again asking and begging, who is willing to step up and break this vicious cycle? Thank you.
Thank you, and thank you for sharing your story with us. Are there any questions for this witness? All right, I do not see any. Thank you.
Thank you.
Next up, we have Trent Manning. Nicole Patano. Jesse LaPace. Welcome to the committee. If you want to go ahead, introduce yourself, and you can go ahead.
Good evening. Can you hear me?
Make sure the button is up.
Okay, that should be good.
There you go.
All right. Thank you, Madam Chair, and the members of the committee for allowing me to speak. My name is Nicole Patano. I am a staff member at the Rhode Island Center for Justice, as well as a member of the Stop Torture Rhode Island Coalition. I would just like to take a minute tonight to clarify what gets at the heart of this bill and what is at the heart of this bill. First, I would like to begin by saying that every single part of this bill is based on the best practices from the Association of State Correctional Administrators, the American Correctional Association, the U.S. Department of Justice, the United Nations Standard Minimum Rules for the Treatment of Prisoners, and the National Commission on Correctional Health Care, as well as successful practices from other states. So first, I would like to say that under current state law, there is no minimum requirement for out-of-cell time for people who are incarcerated at the ACI and placed in restrictive housing. So among other things, this bill changes that. The bill is the first time that the state would provide a minimum requirement for out-of-cell time for incarcerated Rhode Islanders who are placed in restrictive housing. So this would be 2 hours out-of-cell time every day for a total of 15 days in restrictive housing, and then after those 15 days, 4 hours out of cell time. And the bill also provides specific provisions for members of vulnerable populations, such as young people, senior citizens, pregnant women, pregnant people, people with mental illnesses, and people with disabilities. So for anyone who is classified as a vulnerable member of the population, they will be provided 4 hours of out-of-cell time every single day while they are serving time in restrictive housing. So the bill does not eliminate or bar the DOC from the use of restrictive housing or solitary confinement. Instead, it makes the use of it more just and humane for those incarcerated at the ACI. Thank you.
Thank you. Are there any questions for this witness? All right, I don't see any. You want to go ahead, introduce yourself, and go ahead with your testimony.
Good evening. My name is Jesse Capice. I'm a professor of social work at Rhode Island College. I have a doctorate in social work from the University of Connecticut. I'm also a licensed independent clinical social worker in Rhode Island. I worked for years prior to being in academia, working with individuals who had been incarcerated, and again, now teach social work and do research in social work. I mean, in the experiences of people when they've come out of prison. In working in academia, you review a lot of research. And there's 150 years of research on the effects of solitary confinement, and all of them suggest that if you have existing mental health issues, it exacerbates them, and if you don't have any, it's going to give you some. There's I'm not a correctional officer, and I've never been a correctional officer, and I have zero doubts that it's a very stressful and complicated job, and I would imagine having solitary confinement to use that as a disciplinary measure is helpful. But at what cost, right? When you hear about, and you're going to hear the lived experiences of many people tonight, the hallucinations that people experience, the panic attacks that people experience, the bouts with chronic depression, the suicidal thoughts, the suicide attempts, the uncontrollable shaking, I think it's very easy for people to imagine these things happening to folks while they're in solitary confinement. But it's really important to understand the statistic of how many people are released, and the percentage of people released is 98%. So I want you to imagine these things happening to people out here in the community, right? So when someone hallucinates, don't imagine it happening in solitary confinement. Imagine it happening at like Stop and Shop, right? When somebody is having a panic attack, don't imagine it happening in solitary confinement. Imagine happening it on 95 when we're stuck in traffic, right? Or when they're at a movie theater with your family and your kids there too, right? We're the ones who have to deal with the effects of solitary confinement, right? The people outside the community, the correctional officers don't have to deal with the effects of solitary confinement inside. And so that situation, again, imagine if someone's suicidal, we call the cops show up. Now who's dealing with it? The cops are dealing with the effects of solitary confinement to a much more complicated situation that they're now arriving to. And so I would imagine that there are certainly some short-term benefits to a little bit of solitary confinement. 48 hours is what the evidence suggests is okay. Beyond 48 hours, it's causing more problems than it solves. And so, we're delaying these effects. And if we're using it for more than 48 hours, we're putting ourselves in a situation where the community now has to deal with this, in addition to all the individuals are going to hear from tonight in their own individual lives. I appreciate you letting me speak tonight. Thanks so much.
Thank you. Are there any questions for this witness? All right. Seeing none, thank you both for your testimony. Next up, we have Steve Mattal, Denise Jamian, Tyrone Shell. Welcome to the committee. If you want to go ahead and introduce yourself, you can go ahead with your testimony. Make sure the button's up.
Can you hear me now?
There you go.
Okay, thank you. My name is Stephen Mattal. I did 70 years in prison on my last stretch, and I was a law clerk during that time, most of the time. And I also, during the beginning of my sentence, was in trouble quite a bit because I was fighting my sentence, and I didn't think I deserved to be there. But being a law clerk, part of my job was to go to segregation and make sure people had materials to fight their case and books to read and so forth. But the instance that really comes to mind wasn't at one of those times. While I was being disciplined myself in the late 90s, maybe 2000, 99, 2000, I was in there with an inmate called Roger Belair. And Roger had mental issues. He was in there for, I don't know what, but while he was in there, he started tearing up the sink and the beds, so they felt they had to discipline him further. And they locked him up, and before they would let him out, I guess he kept acting up. He didn't want to be there, and so they shackled him, and they handcuffed him around his waist, what they call a black box. And when it came time to shower, they would escort him down to the shower with a chain going from the shackles to the black box, so he had to bend over. He couldn't even stand up straight, and that's the way he had to shower. He couldn't even wash himself. When I was released, I left him my cosmetics, and next time I heard about Roger, he'd killed himself. I was more fortunate than most. I get out almost, it'll be 3 years ago in April, and I kept my sanity, although I did 5 years in segregation off and on. Three back-to-back B statuses, which 90, 120, 120, 120, a couple of C status stints. But during that time, I kept reading and exercising. I took care of my body. When I went in, I had hepatitis C, so I knew I was pretty confident I was going to get out someday. And I wanted to live and be fit for my family to have a life. So I read a lot. I studied the law for years. I won cases for people. I won my own case, as a matter of fact, in 86, 87. And then I was reconvicted. But I think that's what kept me sane, was that I exercised and I read and I studied, you know. But I didn't come out of it unscathed, to be honest with you. I hate to say it, but I've never been convicted of rape or anything like that. But when I look at a woman, I look at them different these days. I'm going to leave it at that. And that's all I got to say. Thank you.
Thank you. Are there any questions for this witness? Great. Welcome to the committee. If you want to introduce yourself, and you can go ahead with your testimony.
Hello, can you hear me? Hi. Good evening, everyone. My name is Denise Jamin. I'm a mother of 2 and formerly incarcerated. I served 6 years in prison. 14 months of those 6 years was in segregation. During my time in seg, I felt scared, confused, and angry. There were times I felt like I was going mentally crazy. Constantly hearing the other inmates scream all day was very, very depressing. I very much felt alone, and the thought of suicide even crossed my mind several times. If it wasn't for the thoughts of my kids, or being able to write to my family and friends, or reading the occasional book or Bible from the librarian or chapel, I don't know how I would have survived. No psychiatrist or counselor ever came to check on me, just a correctional officer during count time and chow time. In conclusion, while the concept of imprisonment is also intended to rehabilitate the incarcerated, being in segregation for long periods of time has proven to be very detrimental to one's health. The only solution is to pass the Reform Solitary Confinement Act. Thank you.
Thank you. Sir, you may go ahead.
All right, my name is Tyler Shaw. I'm an correctional informed inmate, and in regards to me, I was in for almost 27 years last time. I was doing lifeline installment plan from the beginning. I started when I was 16 up until I'm 60 now. But in the process of me doing my time, I did solitary confinement, and I did a lot of it. And then the last time I was in prison, like I said, I did almost 27 years, and I wanted to rehabilitate myself. I was in and out of SEG. Don't get me wrong, I'm not an angel. I was doing things that did cause me to go to SEG. But in the process of me being there, I was getting messed with, which it was on me because I put myself in there. And I wanted to get my education and all that. It took me 32 tries to get my GED. When I did get out of SEG, I did it. I stuck to the plan I had to get myself rehabilitated and get it back out of prison. And I did it. Here I am today, better than myself, because solitary confinement does hurt you. It drives you crazy. And I said, they may have my body, but I'm not going to give them my mind. And I fought to stay the way I am today to do what I'm doing.
Thank you, sir. Any questions for this witness? And any questions for the prior witness as well? Hearing none, thank you all for your testimony.
You're welcome.
We'll bring up the next group, Brandon Dawkin, Richard Ferruccio, and Haley McKee.
Brandon's not here. We're gonna get
Bob Marshall. Stephen Brown. Jeremy Costa.
Acosta.
Mr. Ferruccio, we'll let you proceed at this point.
You have other names as well?
We do have other names. Harrison Tuttle. Harrison still here? Lauren Delgado. Jackie Kennedy. And is it Daniel Cardy? Duvall, okay. Trent Manning. Samuel Theoris. Come right up. Oh, it's going to get him. Why don't you start off, Mr. Ferruccio?
Absolutely. Can you hear me now? All right.
Yes.
Well, good evening, Mr. Chairman, members of the committee. My name is Richard Ferruccio, and I'm the president of the Rhode Island Brotherhood of Correctional Officers. I'm honored to be able to speak today about this very important piece of legislation. I'm also a correctional officer with almost 39 years' experience at the Department of Corrections. My testimony today will be based on my years of experience as a corrections officer. This legislation before you is extremely dangerous and I believe will jeopardize the safety and security of the inmates that are held at the Department of Corrections and the correctional line staff, most of whom I represent. The ironic part about it is we're concerned about the inmates, and I can tell you right now, as someone who works in the prison regularly, 95% of the inmates are doing the right thing. 95% of the inmates I've talked to actually can't believe that this legislation is moving forward. They're concerned because they don't want to see a return to what was the once ACI. Of the 1,000 of bills that are submitted and up for discussion this session, in my opinion, this is the most dangerous piece of legislation. This legislation would significantly alter the discipline process at the Rhode Island Department of Corrections. Just so you understand, the discipline process is very similar to the criminal laws of the state of Rhode Island. Disciplinary units are kind of like the prisons within the prison, just so you understand it. This legislation would extensively reduce the penalty for violations of the Department of Corrections discipline policy. It also states that no members of the vulnerable population shall be placed in disciplinary confinement. This would provide basically a get-out-of-jail pass if you're under the age of 22 or over the age of 60. Imagine Rhode Island communities if we didn't hold those under the age of 22 or over the age of 60 accountable for breaking the law in society. You'd have chaos. If this was the law, when 83-year-old John Carrillo, who was serving a life sentence for the murder of Rhode Island Correctional Officer Donald Price, he wouldn't have been subject to any discipline when he stabbed another correctional officer in 2018, because John was 83 years old, over the age of 60. Or if any inmate under the age of 22 who decides to ignore the prison rules and physically hurts another inmate, no discipline, no accountability. As I said, this legislation significantly reduces the penalties for breaking the rules at the Rhode Island Department of Corrections, and we believe will create chaos. Ironically, if these changes are ever enacted, we would look for other tools to control our population. We have looked at one of the tools we've looked at is criminally charging every inmate for violations of Department of Corrections rules, since most of the rules can be matched to a violation of Rhode Island general laws. Stealing, threatening, possession of illegal drugs, or assault all could result in criminal charges. Another alternative that we looked at and are looking at and pursuing right now is the use of the Superior Court 32F, which is a probation violation for serious infractions of not complying with keeping the peace and being of good behavior while incarcerated at the Rhode Island Department of Corrections. I've looked at it. There is case law that supports its use, and we believe this may be a tool that will be necessary. Ironically, instead of time in disciplinary confinement, inmates may have to serve additional years in prison. I also will tell you that this legislation is poorly conceived, and I wish we had an opportunity to sit down and work with the sponsors. The Department of Corrections, while not perfect, is one of, if not the best run Department of Corrections in the country, and our safety record more than supports that statement. We have an incredible group of men and women who put their lives on the line every day in the name of public safety at the Rhode Island Department of Corrections. You may all have seen our tagline, the Rhode Island Brotherhood of Correctional Officers tagline, representing those who work the toughest beat in the state. Rhode Island correctional officers earned that because in the 1970s and 80s, the ACI was a very dangerous place. Not because we didn't have a good group of correctional officers there. We had good quality correctional officers. Those officers had no tools, basically. There was no discipline, there was no control at the ACI. The staff didn't have tools to effectively manage the facilities. The Rhode Island Department of Corrections discipline process, as I stated, is one of the most important tools we have to manage our department. And today, the ACI, as you've heard many times, is a very different place. We currently operate, again, one of the safest, best-run prison systems in the country. And this legislation would undo that hard work and sacrifice to get there today. You'll see this legislation was passed in New York State. I included a press release that the New York Correctional Officers Union put out. It's in the packet. Warden Salisbury actually commented on it. You know, take a look at it, because right now, the New York correctional system is in chaos. It was enacted in April 1st. Last year, 2022, it was enacted. It was the single most violent year in New York State corrections. Like, their press release is included in the packet I gave you. This legislation will also invalidate the tremendous work of the 2016 Commission to study the use of solitary confinement at the Rhode Island DOC. I was a member of that commission. That commission spent an extraordinary amount of time to develop the discipline process we use today. It's included in the handout. That would be eliminated if this legislation became the law. That commission, created in 2016, was a result of similar legislative hearings. The commission also had to deal with the problem of witnesses lying and attempting to mislead the commission with false testimony. The commission held hearings on 10 different nights over 9 months. Many of the hearings went until almost midnight. You know, we heard testimony from a number of subject matter experts, all in the areas surrounding corrections law and policy, relating to the use of solitary confinement, including physicians, psychiatrists, clinical psychiatrists, social workers, and officials within every relevant field at the Rhode Island Department of Corrections. As I stated, we heard testimony from inmates that lied about their negative impact of the discipline process at the Rhode Island Department of Corrections. One of the most compelling witnesses was testimony given by an individual named Jose Davila Lamosa. Ironically, Mr. Lamosa, when he came into prison years later, had a tattoo across his chest, "Abolish prisons," which basically tells me where he was coming from. Mr. Lamosa passionately explained his time incarcerated at the Rhode Island Department of Corrections and his results of the disciplinary process. He testified how horrible his treatment was by Rhode Island correctional officers. He testified and explained to the legislators about his ongoing mental health issues as a result of his time in isolation. And at one point, several legislators showed incredible compassion for Mr. Lamosa because he started crying, and they gave him a few minutes to collect himself. Senator Lombardi was actually one of the most compassionate things I've seen done. Told the gentleman, please take some time, get control of yourself. I will tell you, it was an Oscar-winning performance. And I say this with some frustration because you see that Mr. Lamosa, everything he said was a lie. He had never actually been incarcerated at the Rhode Island Department of Corrections. He was never placed in solitary confinement. Jose Davila Lamosa had been locked up in Florida, that is accurate, for a violent assault on a pregnant woman and some very serious drug possession charges. Ironically, he did serve prison sentences following his testimony in 2016. In Rhode Island since 2018, I've included a copy of his criminal record. Take a look at it. I don't know what to expect from the former inmates who will testify about their time with the Rhode Island disciplinary system. Last year's group, not one, not half, but 100% gave false testimony into this regarding their DOC institutional records. I will provide this committee with a detailed criminal history of each witness who testifies today, along with a copy of their discipline time served and the reasons why they were in discipline, so the committee can help determine and sort the facts. As the president of Rhode Island Brotherhood of Correctional Officers, I stand committed to working with anybody who wants to improve our outcomes. That's our goal. That has always been the goal of the Rhode Island Brotherhood of Correctional Officers, to run safe, secure prisons. We care about the population that's there. We want to see them improve. So I always will stand committed to working with people to have us get better outcomes. As I said earlier, not a perfect prison. We do some things better than others, but we are lacking in prison programming. And these are things that we're willing to work with the community to help improve. So I'll take any questions you might have.
Thank you, Mr. Ferruccio. Questions for the witness? Thank you. Ms. Kennedy, is it?
Yes.
Please go ahead.
Hi, thank you for giving me your time. My name is Jackie Kennedy. Obviously, I'm not the Camelot Kennedys. I'm here to tell you what being incarcerated did to me, being in segregation did to me, and how I move forward from it. I did something to get incarcerated. Yes, I did. When I was incarcerated, I did something to be put in segregation. Yes, I did. Being locked up for 23 hours a day is not right. It's not humane. I'm a mother, I'm a parent, I'm a dog owner and an animal lover. When my children do something wrong, what I do not do is put them in their room for 23 hours a day, ever. It's not right. There has to be a better way. I can remember counting tiles on the floor to keep myself from not going crazy. I'm not saying don't punish people. I'm not saying that people who do things wrong should not be punished. What I'm here to say is locking someone up for 23 hours a day is not right. Use whatever tools you need to use. If someone has a mental ability, a disability, we can see that. We see that on the streets every day. Drive down Broad Street, Broad and Elmwood, if you want to see it. We see it every day. Those people need to be treated. Because they did something wrong, we don't treat them. We throw them away. They're throwaway people. I'm not going to go into the horrific treatment that was given to me because other people will tell you that. What I can tell you is my fiance, who sits behind me, has woken up numerous times with me screaming out of my seat, out of my bed. My biggest fear in life is to go back to that, so I don't do it. I try to pull up other young people behind me. This gentleman to my left said, let's sit down and have a conversation about this. So adults in this room, let's sit down and have a conversation about this. I appreciate your time and letting me talk.
Thank you. Any questions for this witness? Thank you for your testimony. Haley?
Good evening again, committee members. And my name is Haley McKee. I am here tonight in strong support of this bill. I've been working alongside the coalition for a few years now. I'm no longer formally involved in that kind of capacity, but I can say I've seen a change, I hope, a positive change. It went from the first year I was involved to it solitary being a thing that didn't even exist. There was a lot of denial that this was even a practice in the state of Rhode Island. To tonight, I'm hearing from administration, I'm hearing there's some validity that they're trying to reform their practices, and I hope that they keep on moving in that direction. I'm just really sad that my friends behind me had to pay the price for that to happen. I only did a few days in the hole, as they call it, when I was incarcerated. I was in the midst of a drug detox. There was no medication available for me at that time, so they did what they would do probably for most people, and threw me in solitary confinement for a few days. And I heard the screaming while I was down there. It was one of the eeriest things. I didn't know what I was doing down there. There's no sense of time, lights. I give my friends a lot of credit for surviving those conditions for days, weeks, months, and years at a time. I've worked with people throughout this coalition to help them with advocacy to find their voice despite what they've survived. And I remember one gentleman in particular who had just gotten released from 4 years straight in solitary confinement to the street. So there was not even a reentry into general population to transition outside of a box. He was released right to the street, and I bet you can imagine what that looked like for that person. I haven't seen him in some time. I can guess that he's probably not doing so well. I do think that it's important for the state to codify the practices, because we know that there's outliers. I still get phone calls quite regularly from the High Security Center, from people who are still incarcerated 450 days in solitary for an overdose. Along with the years loss of good time. There are outliers in the system, and I know that people are still experiencing this regularly. While some things sound a little bit different this year, unfortunately, other things sound the same. And we're back in a position where we're coming forward and advocating. And there's information that we weren't even able to APRA last year because it's not public. It's actually property of the state. Our disciplinary records from behind the walls are not public information. To my knowledge, they're not supposed to be circulated by department employees. And it's used as kind of a deterrent for us to come forward and tell our truths about what we suffered, experienced. And I'll say that some of my friends who are amongst us tonight are the strongest, most caring, compassionate, intelligent people that I've ever met in my life, and they're dedicated. Most of them are here in a voluntary capacity tonight. And it just makes me sad that some of our worst moments, and I know my car accident is probably included in the packet that was 100 pages long last year, is probably included in whatever was handed to you this evening. And I don't hide my past, you know. I'd like to think I've grown from it. It's just unfortunate that, you know, myself and my comrades are being forced to relive it. And I just wish that wasn't the case. And I hope it doesn't deter the people who are also coming forward tonight to speak their truths and what they experience. So I appreciate your time this evening, and I'm happy to take any questions.
Any questions? Thank you all for your testimony. The next witnesses we have was Samuel Thea Harris found? I guess not. Joseph Benton. Geraldine Boyku.
Not here.
Okay. Liam Nason.
Not here.
Leonard Jefferson. As long as you make sure it's on with the button up, you can start, sir, at your convenience.
Is it? Okay.
That's working.
Thank you. Good evening, committee. My name is Sam Theo Harris. I'm in charge of the Stop Torture chapter at Brown University. A large number of your constituents are unable to be here tonight. These are the constituents that are most immediately impacted by Senate Bill 617. I'm, of course, talking about our neighbors who are currently incarcerated. We, as a collection of university students and as residents of Rhode Island, are here to lend our voices to them. You will hear excerpts from letters sent from the ACI, read by a number of my peers. Let me be clear, these letters are not a relic of the past. They are not the practices of RIDOC 10 years ago. The letter that was submitted the furthest back is from 2 years ago. They shed light through firsthand lived experience on only a small portion of the practices employed by the Rhode Island Department of Corrections. I say a small portion to note the absence of the voices of those who have passed in and as a result of their custody within RIDOC, as well as those who have had their faith eroded by years of inaction from this legislative body on issues most impactful to them. As you listen to each testimony, it's important to keep in mind that solitary confinement or restrictive housing, as proclaimed by the Rhode Island Department of Corrections, is to serve one purpose. It is only for individuals who pose a serious risk to themselves, others, or the institution of the ACI. If we are to believe that solitary confinement is a tool that is used by correctional officers, we must be able to see it being used in that way and only in that way. Because in many cases, the only difference between a tool and a weapon is how and when it is used. Thank you.
Any questions of this? Any questions of this witness? Sir, you may proceed.
Yes, sir. I want to first of all thank the Vice Chair and the honorable members of this committee. My name is L. Joseph Benton. I am currently a minister at okay. I'm currently a minister at Beloved Tabernacle. I'm also a formerly incarcerated person. I served a life sentence. And during that time, It was a struggle for me, and it continues to be because I'm still in therapy and I spend time with the bishop. Our church is on 628 Union Avenue. I am the lead person on the individuals coming back from prison that you may see in the street, suffering with mental illness. I sat during a finance committee and Kaylin was sitting to my right. And this is one of the problems I have when staff come here and give you a distorted perception of what is currently happening at the HCI. And it's also insulting to say that we're liars. I wanted to leave, but I'm going to sit here and tell my truth. But I deal on a daily basis with individuals who are damaged goods. Damaged. And so I wanted to stay to appeal to your sense of humanity. Wondering if you have any compassion for those who are sick and suffering. I think this honorable body oversees this place. And I'm hoping that the word reform rings a bell. Last time I was here, they said everybody talked about end solitary confinement. That's not possible. But what is possible is that we can reform solitary confinement. And we need to reform it. In my neighborhood, and a lot of people don't care about where I come from. I'm a South Providence guy. And the pastor has sent me out here in the street. There's guys sleeping in the graveyard. Most of these guys I know from prison. Some of these guys I know from segregation. Are sleeping in the street. And then there's this warming center where guys are hanging out all over the place. When they see me, I try to pray with them or whatever to try to encourage them that come to the church, get something to eat. We can feed you, help them get clothes. But it's a shame that people come here and distort the truth. And you all know the ills that's going on, especially in my community. Last time when I was in front of the Finance Committee, Rep. Wilkinson asked Ms. Kaylin Robinson, does the light stay on 24 hours a day in the back of the hospital? Her response to Rep. Wilkinson was, I don't know because I go home. So to sit here and listen to them give you this glorious picture about all the wonderful things they do, it's not true. I don't have to lie, primarily because God is who I serve. So for me, lying is not an option, and I deal with these people every day. Think about it. People are sick and suffering, and we want to paint these pictures of how we're going to heal them and all this kind of stuff. Reform this solitary or reform this confinement situation. It's got to get changed. It can't stay this way. And then when they come to my neighborhood and they act out, nobody cares. And I'm going to say this last thing, and I'm going to say this to you. I'm not a racist by any long shot, because I talk with Frucci, I talk with everybody. But you know that there's a problem there with racial tension. You know that. And to sit here and deny that that's not a real issue, it's true, even in segregation. If there's a dislike for a certain individual or because one officer comes in, hey, listen, last year officer was well, it was more than last year, probably 2 years, was indicted for leaving an inmate to his own resources, and the inmate died. And there's more cases like this, and this is just not, please listen. I don't want to get upset because I have to control myself at all times. But when somebody comes up here and distorts the truth, it just burns me up. I spent a life sentence there. I know what goes on. I know it. And I know what happens when you're trying to reintegrate. People say, hey, pull yourself up by your bootstraps. How can you do that if you don't have any boots? So listen, I'm not going to get angry at anybody. God bless you all. And I said what I had to say. And if you want to ask me any questions, please do, because I got a lot of answers.
Thank you. Are there any questions for this witness? All right, I do not see any. Thank you for your testimony. Welcome to the committee. If you want to introduce yourself, you can go ahead.
Yes, thank you, Madam Chairman. My name is Leonard Jefferson. I've served quite a bit of time at the ACI, about 17 years total, 11 years between 1973 and 1985, and then 6 years between 2013 and 2019. When they brought me back to the ACI in 2019, they had me unlawfully sentenced to life without parole. And thank God the Supreme Court of this state saw that I was unlawfully sentenced to that life without parole sentence, and they overturned it. So here I am today. But I say that to say that during my time at the ACI, for the 6 years between 2013 and 2019, my full attention was directed toward getting out of prison, as you might well understand. Being sentenced to life without parole kind of like is a big preoccupation. There's nothing on your mind other than to, get the situation straightened out, and especially when you're wrongfully sentenced to that. Right, so I say that to say that I was not causing any problems in the jail. And by the way, I'm kind of like uninformed about the procedure here. I would like to submit this to the record and to have each member of this committee receive one copy of this, because it'll make what I have to say crystal clear. Just for the record, and 2 pages. Let's go with this one. Thank you. About us being liars. Mr. Ferruccio has done us a great favor today in promising to show you the disciplinary reports, including mine, because what I want to speak to you all about is the reasons why I was in segregation. On November the 10th, at about 6:30 in the evening, I was taken to segregation because I refused to go out in the recreation yard, and it was cold out there, and none of us were issued coats or long underwear. So we were out there, or were to be out there in scrubs, thin cotton materials, cold out there for a whole hour. I refused to go. So I was taken to segregation, spent the next 20 days there. Right. What I would like for you to have in front of you to see is the second time that I was sent to segregation, it was for making this drawing. Right. I don't know. Do they have copies? Oh, they were already made.
Did they offer for the?
Yeah.
Oh, okay. But anyway, you're going to see when you look at the disciplinary record, right, that this drawing was confiscated from me, and it was said to be a drawing of inmates assaulting correctional officers. But at the same time that the drawing was confiscated from me, they also confiscated a Boston Herald newspaper, which had this in it. It was the model for the drawing. So they knew that the drawing actually depicted an incident in Revere, Massachusetts, where an individual had assaulted and injured 7 police officers. But yet and still, when you get the disciplinary reports and you look at them, please pay careful attention, because it tells you right in there that they will tell you that this drawing is a drawing of officers, correctional officers, being assaulted by inmates. And they full well know that that was a lie. So let's talk about who was lying here. Not me, but the Department of Correction officials. They lied. For what purpose, I do not know. But I do know that the result of their lies was that I spent 20 days in segregation. And because of those 20 days in segregation and the nature of the accusation against me, my custody level, which was actually minimum security, was raised to medium security. Next time I went to the classification board, because of their lies. So what I say to you is that solitary confinement is misused and abused. If someone happens to not, a CO happens to not like you, he can tell a lie, and the officers above him will not correct that lie. This is kind of strange play on words, but in the Department of Corrections, corrections aren't made amongst the correctional officers. When a staff member make a mistake, he is not corrected. He is surrounded by his fellow officers, and the falsehood is put forward as the truth, as you will see when you look at the disciplinary report that Mr. Fruccio is going to give you. And I thank you for your time and listening to what I had to say.
Thank you for your testimony. Are there any questions for this witness? All right, I do not see any. Thank you all for your testimony. Next up, we have Johnny Santiago, Ed Couture, and Nick Horton. We'll start on my right. You can go ahead and introduce yourself, and you can go ahead with your testimony.
Hey, good evening. My name is Johnny Santiago. I'm a member of this community, Providence, Rhode Island, born and raised. I've been out of prison for about 7 years. The last time I was there was in 2016. I did 3 years. Out of that 3 years, the majority of my time was in solitary confinement and segregation based upon my behavior in there. I just want to speak briefly directly to all y'all here and just letting y'all know the effects of solitary confinement for people that may have made some poor choices in the community, maybe not having the greatest of resources, but taking full responsibility. It was very impactful for me. I didn't really understand as far as what I was enduring. Brother Brandon spoke on sensory deprivation, and to this very day, it's very difficult, for certain cadences, like for an environment such as this, for me to be able to tell you and say, hey, a lot of you people here may not ever be incarcerated, let alone have to face being in solitude for a substantial amount of time. And I really would like for y'all to, on a human level, take some consideration. We've been up here a few times trying to advocate for people to rehabilitate, get back home with their loved ones, their families, and be productive, have a chance at this life thing that we have. So I just want to touch base and just basically say that this is coming from someone that's done over a year and one stint in solitary confinement. I don't believe any of the punishment that was given to me actually helped in the rehabilitation of me going back into society to be a productive father or business owner, if you will, or just making sure that some of the youth don't fall into the same footsteps as, somebody that's here before you saying, yes, I take full responsibility for my actions, but some of the practices in the establishments that you have are not benefiting anybody here. And if y'all could really just take a moment to consider that, and maybe we can revise some things, and hopefully we can continue to talk and have a better relationship in our community and broadly. So I just want to touch base and say, just something real quick directly to y'all. Thank you for having me.
Thank you. Are there any questions for this witness? Great. Thank you for your testimony. Nick, go ahead.
Hello. Thank you, Senator and committee. I'm the co-executive director of Open Doors. We're the first and largest agency in the state primarily focused on helping people that have been in prison. We work with about 1,000 people a year and house about 135 people every night. I myself have been working there since 2004. And I say this to make it clear that our agency is dedicated above all to community safety. And we know from direct experience many of the various challenges throughout the prison and law enforcement system. I taught inside the ACI for several years myself. I'm also part of the Stop Torture Coalition, and we submitted a letter from the coalition to you all that was signed by long list of partner agencies and supporters. I want to point out a few. The Barrington Interfaith Partners, the Rhode Island Catholic Conference supports this legislation, and I believe they submitted their own letter themselves as well. The Rhode Island Medical Society and the Rhode Island Psychiatric Society. First, I want to push back on a couple statements that were made previously today. One was that a lot of these abuses no longer happen. Obviously, it is difficult for us to get data and full records. The department is not fully transparent. But we have recently acquired some. One of the members of our coalition got a copy of an infraction of someone who was sent to disciplinary confinement for a significant amount of time. I believe it was 15 days. For walking past someone else's cell and not alerting the guards that that person was ill. It would be hard for me to understand how that could be a justification for punishing someone so severely. It is not the job of the people in prison to guard the other people in prison. That seems to me to be an arbitrary and capricious use of power. Also, I want to push back just, there was a lot that Mr. Fruccio said that I think people found hard to hear, but he keeps saying over and over again that a 19-year-old or a 21-year-old couldn't be punished. We have said to him so many times that's not what the bill says, and he keeps making that same argument. I don't understand why. It just doesn't seem genuine. The bill clearly says that vulnerable populations, people that are in these certain age groups could still be put in disciplinary confinement. They could still have privileges taken away. They just get 4 hours out of cell. That's the difference. They can still be punished. The changes in this bill will make the DOC run better. They're practical and achievable. Over the past years, I've spoken to multiple current and former DOC staff that support these changes from the state and from others. And I'd like to draw your attention to testimony provided to you by the Director of Facility Operations and Clinical Director at the North Dakota Department of Corrections. Starting in 2016, North Dakota instituted many of the best practices in this legislation. As a result, they reduced their rate of admission into segregated housing by 90%, and their data showed that this resulted in no increase in violence. They worked with Amend, an organization that also provided a letter which provides technical assistance to correctional departments across the state. Amend wrote in the letter they are confident that exposing people to long periods of social isolation, idleness, and other harmful conditions, regardless of the terminology used to label a housing unit, breeds more violence and harm that it prevents. I also want to mention that I have, and other members of the coalition, twice sat down with Mr. Fruccio over the last several years, including the previous sponsor of this legislation. So there have been numerous attempts to broker some sort of dialogue. And I realize there's much disagreement between many of the people testifying around how the ACI has been run. And after talking to Mr. Fruccio and to many of the people that have been in segregation, I believe there's also a great deal of common ground. We all want the ACI to operate safely. Mr. Fruccio, in conversation, has emphasized that he does not disagree with the idea of providing more rehabilitative opportunities or the idea of more out-of-cell time for people. At least in conversation to me, he has stated that. And that is what this bill does. That is the essential component of this bill. We also have scheduled a meeting with Director Salisbury, I believe he's out of the room, for this week, which will be our first opportunity to sit down with the director. We've been requesting such a conversation for the past 3 years. We believe that there is similarly many potential points of common ground. At the same time, the DOC has previously expressed an unwillingness to accept any legislation, any language, any statutory language that would govern any of their internal policies on this matter. which was previously stated explicitly by the former director, and I believe was the sort of the gist of today as well. So until the DOC is open to some sort of legislative action, there's not really, I guess, room for a compromise from our perspective. Unfortunately, it is our perception that instead of acknowledging that the problems continue to exist and being willing to work towards solutions, both RIDOC and the Brotherhood have maintained these problems either are not real, not solvable, no longer exist, or fought against any legislative reform. And in fact, have, as you saw today, chosen instead to attack survivors personally by releasing protected private information in a way that actually, to my understanding, violates DOC policy. It happened last year when Mr. Ferruccio released the confidential records of people in prison. It was our understanding that was a violation of policy for him to do that without the permission of the Department of Corrections, and here it seems that he has said he would do that again. Tonight you have heard from the director that the problems we've expressed concerns about have largely been instituted without issue. I think that was sort of the basis of a good portion of Director Salisbury's testimony, that a lot of what we're asking for is or already exists. In that case, it sounds like most of the reforms we're asking for have been accepted, and this legislation should not be controversial. We're only asking for those reforms to be codified. Yet the director, Mr. Ferruccio, also expressed over and over again how dangerous this bill would be if it passed, and I just think we should make it clear that both those things cannot be true, right? If this is so dangerous, yet they have instituted most of the reforms already, then it clearly is not so dangerous. So as a result, we are asking you all to get involved and ensure that the concerns that have been raised by the community and by survivors today are fairly and humanely addressed. Thank you.
Thank you. Are there any questions for this witness? All right, I don't see any. Thank you so much for your testimony. Welcome to the committee. You can go ahead and introduce yourself. Go ahead with your testimony.
Thank you, Senators. My name is Edward Coulter. I would like to say thank you for your time in this matter. I was a formerly incarcerated person at the ACI. Back in 2012, I served 4 years. Within the first 6 months of me being there, I was put in segregation for 45 days and downgraded to minimum, from minimum to medium. While I was there, I also have mental disabilities. I'm wrote down as schizophrenic with voices. So I've had them with years. I've learned how to deal with them, reading books, music, such, so on and so forth. So when I was in segregation, I would ask the COs on a number of occasions, just to get out of my own head, because everybody knows that's the worst place to be, that I get a book maybe to read. They would tell me, you can wait. Every time, they would come by for count, 9 o'clock, 11 o'clock, 3 o'clock, I would ask them for a book. You can wait. When they bring us out to the yard, or the kennels, as I call them, it made me feel like, yes, I'm less of a human. It made me feel like I was a dog in a pound going out to have my little time to go to the bathroom, and I have to come back in. Also, when I was there, in 2013, I was put in segregation for something that never happened. We were told that me and my roommate were fighting in our cells. They put us in seg for 21 days. We appealed. Before we appealed, we went in front of the board. The board gave us 21 days, with 21 days lost in good time and no good time for that month. We appealed it. We both had the same appeal. There was no marks, no evidence, no anything, to bring the conclusion to the fact that we were fighting in ourselves, because we weren't. They denied our appeal. SRU, which is investigation, came down to segregation, brought me to their office, and said, all you have to say is, you and your roommate were fighting, and we'll get you out of seg today. All because they wanted my roommate from back in Max. They didn't want him in medium 1 anymore. And after that, I was just so livid that I felt helpless, discouraged. Like, no matter what I said when I was in there, I was not being heard. It made me feel like giving up. The only thing that made me stop from giving up was knowing that one day I could come out here and hopefully make a change. And that's what I'm doing today. Thank you for your time.
Thank you. Are there any questions for this witness? Great. I don't see any. Thank you for your testimony. Next up, we have Juan Turbides, Patrick Gaines, Ahad Bashor, Justin Lee, Reese Lang.
Some of them will come.
Okay. Welcome to the committee. Patrick, if you want to go ahead and introduce yourself.
Thank you.
You can go ahead.
Thanks so much for hearing all of us testify on this really incredible moral and important moral topic. I'm a voter in Jamestown and don't represent any organization other than the coalition of this group that's been so kind of tirelessly and selflessly spending their time and their efforts advancing this bill. So there's a national trend, it looks like, to legislating around the topic of solitary confinement. As they pointed out, New York has passed a law. It's been abolished. Ned Lamont in the state of Connecticut recently signed a bill abolishing it in the state. There's been activity, legislative activity throughout the country, but Rhode Island has none. Rhode Island legislation or lack of legislation allows for prolonged, unaccountable, and indefinite solitary confinement in the state. The policies and the procedures of RIDOC might, as amorphous as they sound, are not the law. And so, in effect, the law allows for continued abuse and prolonged solitary for vulnerable populations, for nonviolent infractions, and kind of this broad discretion amongst COs and RIDOC to put anyone that they decide with little recourse into solitary confinement. So there's no laws governing that. And as a taxpayer and a resident, that's offensive to me. And it sounds like there might be change underway, but I hope that this panel will take it very, very seriously and act to prevent more abuse and more psychological damage. Did the head of the Correctional Officers Brotherhood, did he just provide you with disciplinary and law and the records of the individuals that are testifying here today? Is that allowed? Could I, as a citizen, access the private disciplinary records of correctional officers that are testified here today as well? How did Officer Ferruccio access these records, And most importantly, what is the relevance of submitting those to you as evidence of any kind here? Is the intention to say that the testimony of these individuals is not legitimate because they had records decades ago from crimes that they've already, the punishments that they've already served? I hope that somebody will look in this committee, will look into and discuss with someone acting in not an official capacity, but a union capacity. We'll discuss with them how they received those records, and again, what the relevance is in discussing these the records of these people that are so impassioned and working so hard to advance this legislation. The trend in the country is to legislate restrictions around solitary confinement. That has been implemented in New York. HALT has been implemented in New York, as you know, as discussed by the Correctional Officers Brotherhood head, as well as our current RIDOC director. And they discuss how violence has spiked as a result of the implementation of the HALT legislation in New York. If they really wanted to not be biased, and if they really wanted to present both sides, they'd show that the level of violence in New York and the chaos that's occurring in New York has been occurring for years and years. And that there is a 10-year trend of violence within the prisons, within specifically Rikers. So to kind of make this anecdotal assertion that the violence is as a result of the restrictions placed on solitary confinement is insulting to this panel, because it's anecdotal at very best, and it was put out by in a political campaign for governor by I think it was Representative Zeldin, who was running, the Republican candidate running for governor. So he made a big deal about cashless bail and restrictions around solitary confinement as leading to these spike in violence, which is just not true. So those are thin arguments, and I hope that this panel will see through that. The Brotherhood of Correctional Officers head asserted that he's only, and his union is only interested in better outcomes. His capacity is to represent the special interests of his group. And that's what was being advocated here tonight. As far as solitary being removed as a tool to enforce rules in the prison, back in the 70s, there was the hole, and it was a horrible place to be, I understand. But violence was rampant in those days. So is there really a connection between solitary and violence? I mean, in those days, there were no restrictions on solitary confinement. The hole was a horrible place to be, and it was as violent as anywhere in the country. So that logic doesn't hold water. This is very much a bipartisan issue. I've spoken for a couple years of working with this fantastic coalition. We had a large event in Jamestown, which was standing room only, an informational event about reforming solitary confinement. It was attended by dozens and dozens of people. I've spoken with people on both sides of the political spectrum. This is an absolutely bipartisan issue because people understand that solitary confinement is a failure, and it leads to incredible damage and by the way, is 3 times as costly to care for an inmate in solitary as it is in the general population. Is there a relationship between that and a union seeking to assure work for their, constituents? Perhaps. Lights on, are the lights on 24/7 in solitary confinement? That's cruel, and it drives people crazy. And again, I'm offended that as a voter and a taxpayer, that my money is going to this kind of abuse and archaic medieval correctional tactics. So is the mission of RIDOC, is the mission of corrections to rehabilitate, or is it to just punish? Because if it's to rehabilitate, the type of cruelty that comes from solitary confinement and deprivation of any social activity or limited time outside of your cell, that's a punishment. And I cannot see, as a layperson, not a professional psychologist, of course, but I can't understand how that could serve to rehabilitate someone and make it safe for them to be to re-enter society. Anyway, thank you so much for hearing us, and I really, really urge you to ensure that this legislation gets passed so we could meet the standard of the rest of the country and not be lagging behind when it comes to our corrections and solitary confinement. Thank you.
Thank you. Are there any questions for this witness? All right, seeing none, welcome to the committee. If you want to go ahead, introduce yourself, you can go ahead with your testimony.
Good evening, senators and members of the committee. My name is Justin Lee, and I'm a student at Brown University, and I'm here to talk about the conditions and the effects of solitary confinement, as well as the lack of oversight. To achieve these ends, I'll be reading an excerpt from a letter from ACI, and I quote, "When I was in medium security, while on this sentence, waiting to come to maximum security, I put grievance in about black mold in my cell. My cell had a window that was sprayed with something on it so us inmates can't see out of it, which was unfair. Stuck in a cell 23 hours a day and can't see outside for 136 days. That will mess anyone's head up badly, 100%. I'm a living fact of it. This 3-year sentence messed my whole life up, very badly, mentally, physically, emotionally, scarred for life. Just because I have mental health issues and need help, don't mean I need to be treated wrong or left alone in a cell with no programs, no fan, no radio, no newspapers, no phone calls to our family, besides a less than 2 minutes than when the staff chooses. So when we come down to DCU, there's a lot more I can write and talk about, but I do not have much paper, and it's the only way to contact my children and family. I would love to help in any way. All I'm doing is telling you what's going on behind these walls. I've only made mistakes in my life. I'm not a killer, nor have I hurt anyone, so I don't even know why I'm in maximum security in the first place. But thank you for your time, and have a blessed day." Unquote. I see the rest of my time. Thank you.
Thank you. Are there any questions for this witness? All right. Seeing none, go ahead.
Hello and good evening, committee. Thank you so much for having us here again to talk. My name is Ahad Bashir. I'm a student at Brown University, and I also am with the chapter of Stop Torture RI. I will also be reading a letter to highlight some issues, such as in this letter, I'm going to talk about an example of an excessive booking, inconsistencies in the use of solitary confinement as punishment or as rehabilitation. And this letter will also be used as an example of why more oversight is needed in the solitary confinement system. Okay, I will now read the letter. In February 2020, after 14 years of being booking free, I went to SAG for the first time for 10 days for a nonviolent incident. It occurred during a pat down in the chow hall during breakfast. CO indicated that I told inmates that he grabbed my ass. What he did was roll my pants up at the waist and pushed on my lower back. I have documented back issues. At the review board, I asked to view the video to ID the inmates. I told he grabbed me and asked why 2 different reports were filed. Both were denied. I appealed and was denied the video again. I wrote to the warden a few months later. The deputy warden denied the fact that 2 different reports were generated. I sent her copies of both reports. Thank you for your time.
Thank you. Are there any questions for this witness? All right, seeing none, thank you all for your testimony. Next up, we have Reese Lang, Alexis Bush, Nina Mankanaka, Tyler Milarani, Angelina Rian Galando, Tessa Rose Crowley, Emma Toussaint. All right, welcome to the committee. You can go ahead and introduce yourself and go ahead with your testimony.
Good afternoon, committee. My name is Tyler Melwani. I am a student at Brown University. So something that the bill really highlights is fixing oversight in the system. And I will be reading a letter from someone from ACI emphasizing this need for oversight. So here are some excerpts from the letter. I'm not even going to talk about grievances. If you file one, you have a target on your back by the COs, and you have an officer who collects the exact same paycheck as the officer he or she is investigating. Same with Internal Affairs and the Prison Rape Elimination Act. We have a deputy warden who used to be the head of the Special Investigative Unit. If you put in a complaint, it's denied. They find a way or make something up. Even when you tell them you don't feel safe because of a specific officer after filing a Prison Rape Elimination Act complaint, they ignore it. I was recently harassed by a correctional officer. I went to SEG for 3 bookings. One of them, he lied and said things I didn't say when I gave my statement and tried to make what was a max of 5 days LOAP into 20 days in SEG. 2 days before, he told me to shut the fuck up when I was trying to go to Medline while I had coronavirus. I was telling them that I had to get my meds. An officer told me while patting me down at breakfast, "You got a problem? It don't matter anyway, you've got no heart. You ain't gonna do shit about it." Then at lunch he said, "Since you like being touched by men so much," and pulled me over again. I was pulled over 3 times that day, at breakfast and lunch. When I filed a written complaint, I didn't hear anything until my uncle called about it in May. A week after I met with Internal Affairs, a wire was found in my light switch, attached to a screw inside of the light. It wasn't mine. If you want to make this place safer, then give the COs body cameras. They're the biggest threat in here. Thank you for your time.
Thank you. Are there any questions for this witness? All right, seeing none, thank you. You can go ahead and introduce yourself and go ahead with your testimony.
Good evening, everyone. My name is Angelina Rios Galindo. I'm a student at Brown University, a member of the Stop Torture Coalition, and the daughter of a man who's been reduced to a figure of 9 felonies. He was first incarcerated at the age of 15 and was last paroled the year I was born. I remember hearing stories about his time in solitary confinement, left with nothing but his thoughts, remorse, and ruminating in the treachery of his conditions. Not a day goes by that I don't marvel at the path he carved out of the things he was forced to overcome. Tonight, I'm here to testify on behalf of an individual who, given the landscape of restrictive housing in Rhode Island, may never get the chance to start over, like my father did. Shared with us in the summer of 2021, this letter starts, "I've been in SEG for more than 3 years straight. I was booked over 45 times, mostly for minor infractions, but I at one point was getting the max penalty for every booking. My experience was torturous, both mentally and physically. I lost 201 pounds during those 3 years in SEG, which is also documented in my medical records. I was actually denied phone calls to my family and visits via request. I was never allowed to go outside, not once, only if I had court, and that's it. I was never allowed to listen to music, watch TV, nor read newspapers or magazines, only books. How can a human being function in a sane way without music or everyday events in the outside world? Think about it. Music and entertainment is universal language for us, especially as people of color. This is what motivates us, drives us to succeed, picks us up when we're down, and fills our hearts with joyful memories. Not to mention, I was deprived access to world news. Why? Why are we not allowed to watch, listen, or read the news or hear about recent events? I missed out on 3 years of life, literally. Just imagine yourself quarantined for over 3 years in one little room, forced to eat the same small portions with no television, no music, not even a newspaper. No fresh air. Not even phone calls to anyone except for your attorney. Being in segregation made me very antisocial. I trust very little anymore, especially when it comes to officers, lawyers, politicians, and more. Have a nice day, and may God bless you. That's the end of the letter. It's trite to say that asking for humane conditions is the bare minimum. The bar is literally on the floor. If folks are incarcerated and thrown into solitary confinement, the question becomes whether or not they'll survive. The prospect of rehabilitation is swept so far out of the picture that you begin to wonder who this practice is even meant to serve. This bill would make strides towards an equitable future for system-impacted residents, but it's still just the beginning. And that's all. Thank you.
Thank you. Are there any questions or comments for this witness? Seeing none, thank you. Welcome to the committee. If you want to introduce yourself, and you can go ahead.
Thank you, committee. Oh, sorry. Good evening. My name is Emma Tusnell. I'm a graduate student at Brown University, and I'm here on behalf of an individual who can't speak for themselves. Before I read this excerpt of the letter, I just want to let you know that this person's been in for 36 years. So I want you to think about what 36 years of your life can do. I can't fathom that. I'm only 21 years old. And just think of the conditions that they're speaking about and how you might get to go home tonight and sleep in a bed, clean your sheets tomorrow. So just keep that in mind while you're listening to this testimony. They are doing what they want. This is a shame, and it changed a whole lot in the 36 years I've been in and out. They don't pass out clothing like other prisons. Matters and pillowcases and sheets, one time for your whole bed. Bed is flat, which messes with everyone's back. That medical has to sell us egg crates, cushions, that don't work. Last year's bill listed 22 and younger, or 55 or older, as a member of a vulnerable population. This is not too broad. What they want to change, it's a 21 and younger and 75 or older, limits very little of the population. People don't start crime till after 21. They don't make it to 75 or older. So this bill needs to stay as is with no change. Thank you for your time.
Thank you. Any questions for that witness? All right, seeing none, thank you. Next up, we have Shalandra Martinez, Austin Wilson, Patrick Quinlan, Patrick Ford, Andrew Lama, Melanie Perez, Eddie Franco, Sam Theo Harris, Justin Mesler. Go ahead, Pat.
Good evening. My name is Pat Ford. I'm the general manager of the Coalition Radio Network, and I rise in support of this legislation. My comments are my own and do not reflect the opinions of virtually any other organization. I'm going to take a few moments to reflect on this issue from an international human rights perspective, but Mr. Ferruccio's behavior I found quite enraging. And I'm going to put these remarks to the chair, obviously, but they're meant to the entire body. Why he was permitted to engage in that level of open threat to a population of individual Rhode Islanders who are sitting before us, why he's able to use his position, illegal or illegally, as a cudgel against the testimony of ordinary Rhode Islanders who are sitting behind us, I find disgusting. And I'd like to understand, and by the way, my interpretation of open meeting rules are that you can respond to me during testimony. You simply choose not to. But I would like to understand why this body did not try and throw him immediately into contempt. Because my next question then is, if that is legal, all right, I'd like to ask you about a guy named Collins Uma. Does anyone here know who Collins Uma is? Collins Uma was an active duty, on duty, Rhode Island Adult Correctional Institute correctional officer who was convicted here in Superior Court of multiple counts of aggregated sexual assault. I forget Mr. Ferruccio mentioning to that. Mr. Jeffrey Peterson is currently under indictment here for manslaughter. while his on-duty behavior as an officer at the Adult Correctional Institute. It can be said that in some cases, officers and members of the highest level of the Department of Corrections have been subject to arrest. Can't they? So where is, in fact, the justice here on just that one issue? 2 years in a row, this has been allowed to happen in this body. And I would like to know if in fact that is legal. I would ask you respectfully as a body to use your ultra-legal, if you will, powers, your ability to maintain oversight, to request the criminal records or the alleged criminal arrests of members of the active members of Mr. Ferruccio's union. And I would ask you to publish them so that as the community has a right to know exactly what type of people are both running and working in this organization. I'd like to take this opportunity to reflect on the legislation from an international human rights perspective. The state of Rhode Island is in direct violation of the United Nations Mandela Rules and as such is a torture state. In a statement issued by the Office of the United Nations High Commissioner for Human Rights, the Mandela Rules provide states with detailed guidelines for protecting the rights of persons deprived of their liberty, from pretrial detainees to sentenced prisoners. The rules are based on an obligation to treat all prisoners with respect for their inherent dignity and value as human beings and to prohibit torture and other forms of ill treatment. They offer detailed guidance on a wide variety of issues ranging from disciplinary measures to medical services. For example, they prohibit the reduction of a prisoner's food or water, as well as the use of instruments of restraint that are inherently degrading or painful, such as chains or irons. The rules restrict the use of solitary confinement as a measure of last resort, to be used only in exceptional circumstances. Mandela himself found that solitary confinement to be the most forbidding aspect of prison life. There was no end and no beginning. There's only one's own mind, which can begin to play tricks. From a letter addressed to President Joseph Biden from leaders of a number of Protestant denominations, as well as the American Civil Liberties Union and the American Friends Service Committee, prolonged solitary confinement is considered a form of torture by the United Nations and leading medical and public health experts. Solitary confinement generally involves the placement of a person alone or with a cellmate in a locked room or cell for 22 hours or more per day without meaningful access to others for any reason, with or without the person's consent, and can occur in pretrial or post-conviction detention. Access to exercise and family visitation are greatly curtailed or completely denied. Permanent psychological harm can result from placement in solitary confinement for even a few days or weeks. In the United States, about 20% of all incarcerated people spend time in prolonged isolation, 4 months, years, or even decades at a time, as is the case in Rhode Island. The United Nations Standard Minimum Rules for the Treatment of Prisoners, known as the Manila Rules, adopted in 2015, offer guidelines for ending the inhumane practice of prolonged isolation. The Mandela Rules call for United Nations member states to prohibit indefinite or prolonged solitary confinement beyond 15 consecutive days for all incarcerated people and ban solitary confinement altogether for vulnerable groups, including children and people with mental illnesses. Key elements of the Mandela Rules and where Rhode Island is in violation. Solitary confinement is defined as at least 22 hours a day spent with no meaningful human interaction. Rhode Island detains individuals for 23 hours. Indefinite or prolonged detention in solitary confinement is prohibited. Solitary confinement lasting longer than 15 days is considered prolonged. In fact, in a case that alleges numerous constitutional violations by the State Department of Corrections, attorneys for the Rhode Island Center for Justice and the American Civil Liberties Union, Rhode Island, have filed a federal lawsuit on behalf of one Joseph Shepard, who the suit claims spent almost 8 months in solitary confinement at the Rhode Island Adult Correctional Institutes in retaliation for exercising his First Amendment rights. Solitary confinement shall be used only in exceptional cases as a last resort for as short a time as possible and subject to independent review, and only pursuant to the authorization by a competent authority. It should not be imposed by virtue of a prisoner's sentence. It is documented, by the way, that inmates at the Adult Correctional Institute are routinely placed in solitary for administrative and minor offenses, often starting with a penalty as a few days, which routinely mushrooms into far longer periods. Former Director of Corrections, Director Coyne Fegg, stipulated in testimony to this body last year. The imposition of solitary confinement should be prohibited in the case of prisoners with mental or physical disabilities, where the conditions should be exacerbated by such measures. The prohibition of the use of solitary confinement and similar measures in cases involving women and children, as referred to in other United Nations standards and norms in crime prevention and criminal justice, to apply. Currently, there is no documented process for establishing these issues in Rhode Island inmates. Some quick hits, some additional violations. Rule 13, all accommodation provided for the use of prisoners, in particular all sleeping accommodation, shall meet all health requirements of health due regard. United Nations standard minimum rules for the treatment of prisoners being paid to climatic conditions, and particularly to cubic content of air, minimum floor space, lighting, heating, and ventilation. The state of Rhode Island is currently in violation of all of that. Rule 14, in all places where prisoners are required to live or work, the windows shall be large enough to enable the prisoners to read or work by natural light and shall be so constructed that they can allow the entrance of fresh air whether or not there is artificial ventilation. Artificial light shall be provided sufficient for prisoners to read or work without injury to eyesight. The sanitary installation shall be adequate to enable every prisoner to comply with the needs of nature when necessary in a clean and decent manner. We are in violation of that. Rule 16, adequate bathing and shower installation shall be provided so that every prisoner can and may be required to have a bath or shower at a temperature suitable to the climate as frequently as necessary for general hygiene according to season and geographical region, but at least once a week in a temperate climate. We are in violation of that. Rule 17, all parts of a prison regularly used by prisoners shall be properly maintained and kept scrupulously clean at all times. Violation of that. So far, the response of the Rhode Island government, incredibly, at a Governor McKee press conference last year, I had the opportunity to ask then Acting Commissioner of Health, Dr. James McDonald, the following question. He stipulated to the fact that the Rhode Island Department of Health performs no health oversight, no health inspections at any of the facilities managed by the Rhode Island Department of Correction. This was affirmed by me in person at a press conference by the current Department of Health Director, Dr. Bandy. Finally, let's talk about Nelson Mandela's cell at Robben Island. A quote from a travelogue. The most powerful part of the tour of Robben Island is a visit to Mandela's cell, a 7 by 9 foot room where a bulb burned night and day over his head for the 18 years that he was jailed there, beginning in 1964. I would point out to you that according to testimony, the size of a solitary confinement cell in Rhode Island is just 1 foot larger. We've been at this for 3 or 4 years. The people involved in this, who have a great deal more patience than I do, all right, have advocated for a responsible process which allows for reaching some sort of commonality of needs and at least accepting the basic principle that the state of Rhode Island Department of Corrections continues to be in egregious violation of virtually every published human rights standard known. It's time to end this.
Thank you. Are there any questions for this witness? Seeing none, thank you for your testimony.
Good evening, Madam Chair, members of the committee. My name is Patrick Quinlan. You're used to seeing me as a lobbyist before this committee. I am here today on a personal, representing myself, not any of the clients that I work with. And I want to basically relate 2 anecdotes, relatively personal. I went to college in between 67 and 71 in Dutchess County, New York, a small Catholic college. As part of my inquiry as to whether I wanted to go to law school, I took a job with the Public Defender's Office for 2 years as an intern. It was a $1 a year job, and it convinced me I wanted to be a lawyer. But something really troubled me about solitary confinement very early in my career as an intern. A student I used to work with in a construction site was a client of the Public Defender's Office. I was sent to the Dutchess County Jail to interview him along with one of the lawyers. And what was really interesting in going there, that the Dutchess County Jail at that time had the reputation of basically finding any reason to put their prisoners into solitary, particularly if they had long hair or tattoos. It was a sheriff that was relatively well known as, quote, the Mighty Quinn in a couple songs from the 70s. So in any event, during that interview, this young man basically said to us, you know, what do you want to do? We have some plea offers here. So the first offer was 1127, which is a term in New York, 11 months, 27 days. It's basically just short of a year, and you do that in the county jail, or 2 years at the state penitentiary. He opted for 2 years at the state penitentiary. It knocked me over. I mean, I knew this kid for 2 or 3 years. I went to school with him. And the reason he said that was that if you stayed at the Dutchess County Jail, I would spend most of my time in solitary confinement. I would rather spend 2 years in Attica, which is where he served his 2 years, than spend a week at the Dutchess County Jail in solitary confinement. So I've always been aware of this. The second anecdote sort of brought it home to me. My son was involved in a gun crime, and he was incarcerated awaiting trial. And he was at the ACI. It was a weapons charge as well as a discharge charge. At least three times during his pre-trial, he was put into solitary confinement. And as a parent, I would see him whenever it was, basically you got a once a week or once every 7 days. But when he was in solitary, we didn't see him. So basically you'd go, they'd say, come back next week, he'll be out, come back the week after. He basically he couldn't even talk to me. I mean, he could get out a sentence or two, and he just would sit there at the table with his hands in his head. He was absolutely, completely, and totally depressed. I had never seen him that way. He was hopeless, basically. So, in my opinion, this bill, having written and read a lot of bills, is a reasonable attempt at compromise. What I would rather see the Department of Corrections and the guards approach this is to look at the language in here, like anyone else coming before this committee, and see what is it that you could agree with in this bill. What is it that is an absolute game stopper that you cannot agree with, and get to the table and do it. Solitary is more akin to torture than it is to rehabilitation, particularly as it's practiced. And I would answer any questions you might have. Thank you for your attention.
Thank you. Are there any questions for this witness? All right. Seeing none, thank you. Welcome to the committee.
Thank you, Madam Chairwoman. Members of the committee, good evening. My name is Justin Mesler, and I am a student at Brown University, and I have a few short letters to share with you all from testimonies from inside the ACI. The first one. I was falsely accused of, quote, opening a window, then threatening a correctional officer. I received 75 days in segregation. When I asked that security video be viewed to prove my innocence, a lieutenant on the one-man disciplinary board claimed security footage is not used to clear inmates' bookings. He had turned off the tape recorder as he said this. I received 30 days in segregation because I flushed my toilet during a surprise raid. The fact that I was relieving myself and doing something so habitual as flushing when finished was never considered. A non-violent, made-up booking to send a man to the hole for 1 month. I would ask members of the committee if, that's the end of the letter. I would ask members of the committee if it makes sense to subject someone to what we know is internationally deemed as torture for flushing a toilet after using it or for allegedly opening a window. The second short letter reads as follows. I've been in segregation 18 months. I originally came in segregation for weed, and they gave me 415 days. But since then, I've just kept getting booked. I got locked up when I was 16, so I'm still young. I'm just trying to make it home to be a better man. Segregation is stressful, though. We're locked in 23 hours a day, 48 on the weekends. No showers on the weekends or holidays. The cops like to spray us with OC spray, unprovoked. I'm a very rational person, and there are many times the CO sprayed me or other inmates for no reason. The disciplinary board is run by a lieutenant who is unfit for reality. He has a way of justifying all of his officers' actions, or lack thereof, and to be honest, I really wasn't trying to write, because everybody talking about reform and nothing happens. This is stressful for me, but it hurts my family more than anything. Not being able to talk to my mom or see her, like I'm focused, but there's times when I'm just too emotional, so I get into trouble. But I got 3 years in on my 5.5, so I'm on my way home. I'm trying to stay patient, prayerful, and humble, and go home a better me. Thank you all for your time.
Thank you. Are there any questions for this witness? I don't see any. Thank you so much. Next up, we have Marina Benson, Elizabeth Coots, Leo Corzo Clark. Welcome to the committee. If you want to introduce yourself, you can go ahead.
Good evening, committee. My name is Marina Benson, and I'm a student from Brown University. I will begin by reading a section of a letter written by an incarcerated older gentleman in the ACI that explains how the conditions of solitary confinement need oversight. In other letters, this older gentleman describes the difficulty of getting his necessary medication in a timely manner. He explains that, as a result of this, medical providers informed him that he may keep some necessary medications in his cell for emergencies. He explains how he has been booked in SEG for this in the following letter. I was just in SEG, and I met the governor's staff that came into Max to see for themselves what is going on. In SEG, one of the gentlemen came over to my cell and looked at my picture and saw that I was a handicapped inmate and 71 years old. He was surprised that I was in there for hoarding my high blood pressure medication and having 2 blank cards that I was not using anymore. He says he was not impressed with the DOC, and then I told him that I had to do 90 days in ARS, which is the step down between SEG and general population. It is still restrictive housing. There ends the first letter. I will now read an excerpt of a letter that explains reasons the writer, another incarcerated member of the ACI, has witnessed being used to send people to SEG. First, I will remind you all of the purpose of solitary confinement as defined by Rhode. Solitary confinement, as proclaimed by Rhode, is only for those individuals who pose a serious risk to themselves, other inmates, or the ACI. The letter is as follows. An officer put an inmate in segregation for only wearing his boxer shorts in his cell while he was sleeping during the hot summer in a building with no air conditioning or central air. An officer put an inmate in segregation for taking a bird bath in his cell during the hot summer in a building with no air conditioning or central air. Note, you are locked in your cell 18 hours a day, every day. To reiterate, solitary confinement, as proclaimed by Rhode, is only for those individuals who pose a serious risk to themselves, other inmates, or the ACI. An officer planted a penthouse in an inmate's cell, then putting that inmate in segregation. The prison supplies all the inmates with movies that have nudity. However, the prison will put an inmate in segregation or discipline him with cell time if he has a nude book in his cell. An inmate told a nurse that this is the wrong medication. The nurse then yelled at the inmate, quoting, "She knows what she is doing." After, the nurse found out she had made a mistake. The nurse then put the inmate in segregation for about 30 minutes. The inmate later put the inmate in segregation for about 30 minutes later for taking the wrong medication. Inmates are put in segregation for kissing the hand of his visitor. Again, solitary confinement, as proclaimed by Rhode, is only for those individuals who pose a serious risk to themselves, other inmates, or the ACI. Thank you.
Thank you. Are there any questions of this witness? All right. Seeing none, go ahead. Welcome to the committee.
Hi. Thank you, committee, for having us and letting us speak. My name is Elizabeth Coates. I'm also a student at Brown University. Like my peers, I am here to lend my voice to someone who could not be. The letter I have to read to you describes the condition that this inmate is facing in segregation housing, noting especially the lack of food and access to news. It also gives examples of excessive sentences. The writer starts saying, "I want to say thank you for helping us in the way that you're trying." They say this building is outrageous when it comes to its disciplinary system. They say, "I'm currently in SEG unit right now writing this letter. The meals are already small portioned, therefore we should be able to buy our commissary and segregation. If you check the records of the infractions that inmates like myself serve time in SEG for, none of them, if not very little of them, are related to meals. We shouldn't be deprived of our food that we bought with our own currency. When they review our inventory of our property, we're never present to at least make sure our property is getting treated with respect. Open bags of food and beverages get thrown away, family photos get lost, and paperwork gets thrown about with no care. I'm not allowed to even receive my Sunday newspaper that I pay weekly for. So while I'm in segregation, all my ties to what's happening in the stock market and the world is at a complete halt. I'm from Providence, and the recent violence in the city has my anxiety through the roof. The newspaper offers some type of solace when I read and see nobody was shot or killed, no kidnappings or anything related to violence. Speaking about someone else that they have spoken to in similar situations, they say there's an inmate in segregation right now serving 30 days due to the correctional officer finding allergy meds that he purchased on commissary on his person. The infraction code on his booking is hoarding medication. Now, the usual 30 days in seg for hoarding medication is when they apprehend an inmate with medication from behind the counter. His booking should have only been Category 2 contraband outside of cell, which only holds LOAP punishment. The segregation unit as a whole should be changed. This person concludes saying, this state system is so far behind when it comes to the way inmates are treated. I've had multiple and many conversations with other inmates who have come from other prisons, and they tell me about their experience in other prisons. Their time is never as hard as ours. This prison is not dangerous where a CO or inmate comes in here and fears for his or her life, so why are we treated as if it is? We just need help. Please help them. Thank you.
Thank you. Are there any questions for this witness? All right. Thank you. Welcome to the committee. You can go ahead and introduce yourself and go ahead with your testimony.
Thank you. Hello, Honorable Chairwoman Boyer and members of the Senate Judiciary Committee. My name is Leo Corzo Clark. I'm also a student. I'm here on behalf of Stop Torture Rhode Island, but I'm also just here as a fellow human being. And I'm here in support of Senate Bill 617. So I'm here to read letters directly from incarcerated Rhode Islanders who could not be here with us today. Letters that directly illustrate the abuses of RIDOC against inmates, the horrors of solitary confinement, and the desperate need for the reforms included in this bill that we are discussing. But before that, however, I'd like to reiterate the definition of solitary confinement as it is practiced in Rhode Island and explain how it's implemented within the state and specifically within ACI. People incarcerated in Rhode Island who are in what's called restrictive housing, solitary confinement, segregation, all synonyms for the same thing. They're placed in an 8 by 10 foot cell and can be in these cells for 22 to 24 hours a day. To give you a sense of what 8 by 10 feet means, the average wheelchair accessible bathroom stall is about half that size. So when I'm talking about this, I'd like you to picture yourself in that bathroom stall for days, weeks, months at a time, as these Rhode Islanders have been. These cells may not have windows. These cells may not have functioning toilets. There may be feces, blood, and other fluids on the floors and walls from previous individuals placed in that same cell. And solitary confinement, as many of my peers have said before, is only intended to be used when an individual possesses a serious threat to themselves, other inmates, or the ACI. And I'd also like you to keep that definition in mind as I share these stories. So I'll begin from this letter, which was sent in the summer of 2021, which, if you can count to 2, is less than the 10 years that other people who have testified today would like you to believe. I had a mental breakdown in segregation, voices, panic attacks. Something was in my cell. I kicked the door to get the attention of the CO, asked to get me out. He said I was just bored. 21 more days to segregation to go with the 40 I was already serving, 61 days in segregation total. Could any of you off the top of your head tell me what the day was 61 days ago? It was January 19th. While in segregation on recreation time, a man on the bottom tier flooded a toilet. I'm on camera on the top tier, never going to the bottom or the bathroom, but I still get booked. 21 days in segregation to go with the 30. 51 days in segregation, January 29th. That man went home the next day. In my cell, no TV, no radio, bored. I made dice out of toilet paper. Cell search, found dice. I was booked for gambling, 10 days in segregation. Booked for yelling out of my cell while in segregation, 5 days loss of privileges. And privileges in the context of being solitary confinement, it means sunlight. It means fresh air. And so 5 days without any of that. My girlfriend kissed me in the visiting room. I turned to walk away, but then turned around for a second light tap kiss. 15 days in segregation. Think of the last time you kissed your spouse. Think of the last time you kissed your child. Now think of spending 2 weeks in that ADA bathroom stall. Me and several inmates in our cells having a conversation about how petty this prison system is. Cop says to stop talking. I say it's a free country. 20 days in segregation. If you don't believe the stories, cross-examine them with the RIDOC's own record I have provided. Then you decide if a set of dice, kissing your loved one, calling your mother on her birthday, having a mental breakdown, and all the other petty issues at hand warrant solitary confinement. And I have those. They were provided by the individual who sent this letter. The dice incident was classified as gambling, which constituted 10 days of disciplinary confinement and 10 days of loss of good time. The flooded toilet incident was described as conduct that disrupts or interferes with the security of ACI, and that warranted 21 days of disciplinary confinement and 21 days loss of good time. And the list goes on and on. So I will start with another letter. Inmates are being forced to clean a contaminated or quarantined cell of hepatitis, flu, chickenpox, and other serious issues, like all inmate body fluids. This prison at maximum security does not have the proper safety gear to 100% protect the inmate's face or the correct size outfit for larger inmates. If the inmate refuses to do the cleanup, refuses to put his well-being at risk, he will be put in segregation or they'll take his current job away from him. Inmates are also denied a shower directly after a blood cleanup or other body fluid issues. Waiting periods for a shower, depending on the superior staff in charge of the cleanup, can be between 1 to 8 hours or no shower at all. Segregation inmates are sometimes given 10 minutes or less to eat, or they get added time in segregation. I'd like you all to think of that definition shared earlier of a serious risk to themselves, other inmates, or ACI. Segregation inmates are sometimes given 10 minutes or less to eat, or they get added time in segregation. Serious threat to themselves, other inmates, or ACI. An inmate disagreed with an officer. The inmate asked to see a superior officer. The inmate was taken to segregation for asking to see a superior officer. A serious threat to themselves, other inmates, or the ACI. Inmates taken directly to segregation for using another inmate's phone number when making a call. A serious threat to themselves, other inmates, or ACI. Oh, this one's good. When in segregation, you get time out of your cell. If you say you are going to hurt yourself, or if you have a medical issue, they will put you in a special cell. You get 0 time out of your cell. It is worse than segregation. It is not healthcare. Due to the fact that you're not in a segregation cell, but rather in a medical care cell, it does not count as segregation time, despite being more severe. Even if you go to an outside hospital for any medical reason, they keep you in the special cell for 5 to 15 days or longer. When you go back to segregation, you now must finish your full segregation time you were disciplined for. So if you were to spend 15 days of, if you were to be serving a 40-day sentence, and 35 days into that, be admitted into a medical cell and spend 2 weeks in that cell, you would have to go back to solitary confinement and spend the remainder of that 40-day sentence, despite having already exceeded it due to just the crime, I guess, of seeking medical attention. And so with this all in mind, I'm really here to urge you, as are all my peers who have spoken before and will speak after me, that SB 617 was written directly to curb these abuses and reform solitary confinement. It guarantees time outside of the cell to those in solitary confinement, something that is not guaranteed currently. It creates alternative punishments for individuals so that solitary confinement is used as a final resort, something not done currently. And most importantly, establishes an oversight committee to ensure that individuals unfairly placed in solitary confinement are able to seek justice and protection from this inhumane practice. And while you will hear from many more advocates tonight, reading letters from incarcerated individuals, I want you to know that we are not alone in our efforts, and these efforts do not stop with just the folks in this room tonight. Already 23 other states and Washington, D.C. have enacted laws that limit or prohibit the use of solitary confinement. Rhode Island is simply behind the curve. It's high time that we as a state bring our practices in line with modern human rights standards recognized both in this country and internationally. And with all that being said, I urge you to vote yes on SB 617. Thank you.
Thank you. Are there any questions for this witness? All right. Thank you all for your testimony. Next up, we have...
Chair, we have, you know it's getting late, so we just want to have 2 more people speak. They were on the list earlier. They wasn't here, so we can just have those last 2 people speak.
All right. If there's 2 other folks that I called, or 2 other folks who want to come up and testify, that's fine. They can come up and just tell us their names. Welcome to the committee. If you want to go ahead and introduce yourself, and you can go ahead with your testimony.
My name is Brandon Dawkins. So I was in high security, segregation and high security for 3.5 years. And so over there, like I don't know. It was like the SEALs and an inmates used to call it mental warfare. Like I got over there. The same month that I got over there, I witnessed an inmate go to recreation and come. He came back. They came back dragging him, and he was screaming out his cell, "I can't breathe, I can't breathe," and nobody came to his aid. He was like, "I can't breathe, I can't breathe." The nurse came. He was still handcuffed, and he was just like, "I can't breathe," all night. The next day, in the morning, he was no response. The nurse came, and he was like, the nurse came, and he was like, "Yeah, I think he's dead. Like, he's not breathing." 2 hours later, the SEALs came. 3 hours later after that, they came with the ambulance, and he was dead. Denard Walker, they beat him until they beat him to death. There was no cameras over there when I first went over there, and I was scared to come out my cell, whatever. So when I finally came out my cell, whatever, to go to rec, whatever, they let me. I was handcuffed, cuffed,
from my ankles and my feet. And the COs didn't like what I did to get over there, and they broke my ribs and then called Code Blue, which Code Blue is all the COs come and they're like, it's a fight or whatever. They call Code Blue and they beat the hell out of me again. Like my ribs already broke from the CO and they beat the hell out of me. But while I was over there for 3 years, segregated. I started hearing, I started like after the first year, I started hearing, I started hearing things. I don't mean to be funny, but I started hearing Super Mario Brothers out of and I thought it was coming out my toilet, on my vent. I thought somebody was fucking with me. Excuse my language. I thought somebody was messing with me. I started hearing doo 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 out of my. I thought it was coming out of my toilet, and I was ready to get up. Every month you got to go see the counselor. Every month they let you go see the counselor because for whatever reason. So I told the counselor I need to get on meds because I'm hearing stuff. I think I'm losing my mind. She was like, no, it's not. You're not losing your mind. It's called deprivation of sensory. You're not supposed to be locked down this long by yourself in a room by yourself. And I was like, how is that normal? She was like, it's not normal. But you're not losing your mind. And I tried everything to I was hearing that and I thought I was going crazy. I was ready to get on all types of medication. And I wrote my mom. I told her I'm not gonna make it out of here. The COs would come to my cell every night. Every night the COs would come to my cell, 3 o'clock in the morning, 2 o'clock in the morning, and just kick my door, just to mess with me. They would take my mail. I wouldn't get my mail for. I was married when I went there. When I got out, I was divorced. They wouldn't give me my mail from my wife and my kid for a month, 2 months. They wouldn't. I would get one visit a month for 40 minutes. And I had to choose. I had 3 kids by 2 different women. I had 3 kids. I had to choose which kid I could see once a month for 40 minutes and one phone call for 10 minutes. I had to choose who I could call. I had to choose which one of my kids I could talk to. High security, I don't know. That's just, I know we're here talking about segregation, but high security segregation is a whole different animal. It's that building should not be, that building should be shut down. I seen so much crazy stuff happen over in that building before they put the cameras up. When I got there, they had no cameras. That's why that kid died. Denard Walker died. They didn't have no cameras. They didn't have no witnesses, so they just said he died of whatever he died from. They said he died from a heart attack, whatever. After he died, they put cameras up. But it still didn't stop them. It still didn't stop the COs and the lieutenants from doing what they did over there. And every 3 months they're supposed to allow you. Every 3 months they're supposed to allow you to. What is it called? I'm sorry. Classification hearing. To allow you to go back to maximum security, minimum security, medium security. But it's just a monkey court. They just do that as a monkey court. Like they know every 3 months there's nobody in this, and there's nobody that went back to maximum security, medium security within 3 months, within 6 months. There's nobody. It's just a monkey court. I seen some of the best guys like that made mistakes. They made mistakes. They came to jail. My neighbor was one of my best friends. My neighbor from my room, from my cell. He was right next door to me. I seen him break down, and I don't think he's never coming back. He broke down. He started playing with his feces. He started sticking pens in his penis just to go to the hospital so he don't got to be in that building. He started swallowing batteries just so he don't got to be in that building, just so he don't got to be in SEG, just so he could go to the hospital and get away from that. Like I seen, and it's not just him. Multiple guys do that stuff over there. Like they do whatever they gotta do. Like they swallow batteries, they stick pens in their penis, just to get out of high security, just to get out of SEG, because they play that mental warfare over there. Like it's crazy, man. And I don't know. Just thinking about it, like it hurts my heart. Like another one of my friends, he was on the other side of me. He started saying that, bro, I think they're putting something through the vents. They're doing something through the vents. This was 2 years in. Oh, they're putting something through the vents. They're trying to kill me. They're putting whatever through the vents. And I'm like, bro, calm down, like relax. Like they ain't nobody doing nothing. He was like, no, I swear to God, they're putting something through the vents and hyperventilating. He's hyperventilating. He's going crazy. He's going crazy. Like you're not supposed to be locked down for that long. By yourself, like isolated by yourself. In order to get out of high security, I had to take a class. It's the only class they have over there in high security. You got to take a class, and I forgot the name of it. But at the end of the class, you got to make a speech about what you learned in the class. When I did my speech, I was shaking because I thought after I made the speech, they was gonna keep me in high security. At the speech, there's the wardens there, the deputy warden, AT Wall, all of them guys, they're all there. I spoke about isolation. After the counselor told me about the sensory deprivation, I started telling my mom to send me like articles about sensory deprivation, about isolation, about all of that. I made my speech about that, about isolation. And one of the things that I said was that I read about in the newspaper that my mom sent me. They deemed it illegal for any animal, monkeys, to be isolated more than a week, but Congress wouldn't deem it illegal for a person, a man, to be isolated. And I spoke on that. At the end of my speech, the warden came up to me. Warden Whedon, he was mad. I know him. I've been in jail, so I know him for a long time.
and he was mad, and he shook my hand hard. He said, "You don't know how to shut up when you're supposed to shut up." A.T. Wall came up to me after him and said, "I've been to Brown. I've been to many Brown speeches. I've been to Brown, many graduations, and this was one of the best speeches that I ever heard." I don't know. I don't really understand what this bill is about, but isolation is crazy, man. Like being locked down, like it's not right. Like it's not right for a human being. If you look at it, they don't allow it for monkeys and animals. So I don't know why they allow for us. Thank you.
Thank you for your testimony. Welcome to the committee. If you want to introduce yourself, and you can go ahead with your testimony.
My name is Lauren Delgado.
Can you just make sure that the button is up on the microphone?
I think it's up. It's up. Can you hear me? This one? All right. Can you hear me now? All right. My name is Lauren Delgado. I'm actually Brandon Dawkins. He's the father of 3 of my children. I've never been in segregation. I've never been locked down. I went to Catholic school all my life. I graduated from Bryant University. But I'm just here to talk about what I have to go through as a woman dealing with children after he went through that segregation period. I've known him for 13 years. We have 3 daughters together. And before he went to jail, I knew him. He was energetic. He was a great person. Like, you could tell him anything. He wasn't nervous. He was just great. And then he got incarcerated in 2012, and he went to High Side, which is high security, which is basically like segregation. They are on lockdown for 23 hours a day. They get 1 visit a month, 1 phone call a month, and he has to choose who he wants to see, who he wants to call, and he has 6 children. So who do you choose? So I couldn't see him, and I couldn't deal with that. So then he ended up getting released, obviously. He got released, and we had our children, and he's just not the same person that he was before he was in segregation. Like, they treated him like he was an animal. He doesn't sleep at night. He talks to himself. He paces through the house all the time. His interactions with my children, he can't hear too much noise, and we have young children, so they are loud. they're wild. They're kids, and that makes him nervous. It makes his anxiety go through the roof. And I have to do that. I had to get counseling to learn how to deal with it. Like I said, I never even had any interactions with the law, but like it affects like that incarceration and that deprivation and what they do to these men and women when they're in isolation. It hurts. It hurts our families. Like at the end of the day, like those are like their fathers, their brothers, their sons, their mothers, their sisters, like, and what happens to those people when they come out of isolation for being in there for so long, it affects their mental and it affects their family life as well. I had to get counseling to know how to deal with his own issues. So it not only affects that person, it affects families. So something has to be done because it doesn't only affect one person. When you go to incarceration, like it's supposed to be rehabilitation, not torture. When you have to rehabilitate these people, send them through classes, like let them interact with their families, because it affects families. It not only affects that person, but it affects the whole of the whole family, everybody around them. And it's a problem. And that's all I gotta say.
Thank you for your testimony. Are there any questions for this witness? If there's any more stories or any written documentation that any of the witnesses would like to share with the clerk, she'll make sure that we all get copies of that and that they get filed with the rest of the testimony. So that does conclude the public testimony on Senate Bill 617. I would entertain a motion to hold by Senator LaMountain, seconded by Senator McKinney. All those in favor? Aye. Any opposed? And Senate Bill 617 is held for further study.